may it continue to please the court, justices. I'll address the issue of remedy and in respect of section 19. And what I propose to do with regard to that is to first explain why we submit that the court has the power to grant the remedy that we ask for, to explain the drafting error so that the court understands the remedy in light of the drafting error, to explain why we submit that the drafting error properly the proposed remedy properly addresses the drafting error consistently with the scheme of the Act and the legislative intent, and then say why it is a suitable remedy and that it meets the three guardrails that our learned friend Ms. Pillay dealt with on behalf of the DA, and why the additional problems that the DA raises lack merit. I must be clear at the outset, we are not asking for the court to suspend any declaration of invalidity in respect of section 19(2) and 3. That's not what we're asking for. There was a suggestion for that remedy in the Minister of Public Works' explanatory affidavit, but as my learned friend Mr. Katz pointed out, by reference to Prince, that power the court doesn't have, and that judgment in Prince is quoted in the heads of argument for the DA at page 22 at paragraph 54, referring to paragraph 2 of that judgment. And it says this, and I need to read it so the court understands why it's said to lack that power. The High Court suspended the order of invalidity for a period of 24 months from 31 March 2017. It said that was to allow Parliament to correct the constitutional defects in the Drugs Act and Medicines Act set out in the judgment. It is neither necessary nor competent for a High Court to suspend an order of constitutional invalidity that relates to a statutory provision or an act of Parliament when it grants such an order of constitutional invalidity. It is unnecessary because Section 172(2) of the Constitution provides that an order of constitutional invalidity has no force unless it is confirmed by the Constitutional Court. That means that any order of constitutional invalidity of an Act of Parliament or a provision of an Act of Parliament made by a court other than this court, meaning the Constitutional Court, does not take effect for as long as it has not been confirmed by this court. Such a suspension order is incompetent because it purports to suspend the operation of an order that is not in operation in any event. That order of invalidity is not in operation because of Section 172(2) of the Constitution, which I've just quoted above. So we don't take issue with that, and we don't ask for a suspension remedy. But you will see that that court in that judgment doesn't say this court has no other power to consider a just and equitable remedy under 172B following upon a declaration of invalidity. It's only limited to suspending the declaration because there's nothing to suspend in effect, even if this court declares the section invalid. What we're asking for is a reading in, which, as the National Coalition case explains, which we all refer to, it's really related to the reading in. They're interconnected because you're taking out a word and replacing it with a phrase or a provision. And Prince does not address that point and does not preclude this court's jurisdiction, which is confirmed by Section 172(2) of the Constitution, because that section says when any court, and this is a court, when any court declares a provision invalid or deals with any constitutional matter, after a declaration of invalidity, it must turn its attention to what a just and equitable remedy would be in the circumstances. But we also say that even if our learned friends were to persuade the court that all you need to do is to declare Section 19 invalid and you can't engage in any other just and equitable remedy, that it would be appropriate for this court to express its views on the reading in remedy, because when the Constitutional Court ultimately decides whether to confirm the declaration and what just and equitable remedy it should grant, it would have the benefit of this court's views, which the Constitutional Court always asks that courts do, because it is otherwise it becomes a court of first and last instance on the particular issue. That's the first point. That addresses why this court can competently consider and grant the reading in remedy. Then the second point, the second thing that I need to persuade the court on is that it meets the three guardrails that the DA referred to. You'll recall that is that the proposed remedy must be sufficiently precise, firstly, and that the court can only do so if it is clear that there's no range of other suitable alternatives. It's no good listing 10 alternatives. There must be suitable alternatives as to concern the court. If it is clear that there are 9, as they've suggested, but only one alternative is the suitable alternative consistently with the statutory framework, that is the only alternative. The others are there just simply for the mention and to create the impression that there is a wide choice for the legislature. The third point was that the remedy must give effect to the legislative scheme and the legislative intent, and must not in that way require much textual surgery that is in conflict with the statutory scheme, because you're not legislating, you're not making a policy choice for the legislature. You're saying we can see the error and we can see what you wanted to provide for. We can see it from the scheme of the Act, and the proposed remedy is in line with that scheme. Then you're not intruding into the legislative role against the separation of powers. You're staying in your lane to give what an effective, just an equitable remedy should be. And before I go into the detail of proposed remedy, it's important to highlight the principles that the Constitutional Court highlighted in National Coalition. Because even though our learned friends for the DA refer to a number of other judgments, such as Arena Holdings and EFF and NA and Dawood, all of them restate those principles. The principles were properly and fully stated in National Coalition. And we have quoted from National Coalition in our main heads of argument at paragraph 75 and underlined what we believe are appropriate guidelines for purposes of the reading in remedy that you're concerned with. At 73, quoting from the judgment, at paragraph 73, it says, having concluded that it is permissible in terms of our Constitution for this court to read words into a statute's remedy and constitutionality, it is necessary to summarize the principles which should guide the court in deciding when such an order is appropriate. In developing such principles, it is important that the particular needs of our Constitution and its remedial requirements be constantly borne in mind. 74. The severance of words from a statutory provision and reading words into the provision are closely related remedial powers of the court. In deciding whether words should be severed from a provision or whether words should be read into one, a court pays careful attention first to the need to ensure that the provision which results from severance or reading words into a statute is consistent with the Constitution and its fundamental values, and secondly, that the result achieved would interfere with the laws adopted by the legislature as little as possible. Then over the page, paragraph 75, in deciding to read words into a statute, a court should also bear in mind that it will not be appropriate to read words in unless in so doing a court can define with sufficient precision how the statute ought to be extended in order to comply with the Constitution. Moreover, when reading in as when severing, a court should endeavor to be as faithful as possible to the legislative scheme within the constraints of the Constitution. Even where the remedy of reading in is otherwise justified, it ought not to be granted where it would result in an unsupportable budgetary inclusion. There was no budgetary inclusion here, just for start. And then 76, it should also be borne in mind that whether the remedy a court grants is one striking down, wholly or in part, or reading into or extending the text, its choice is not final. Legislatures are able within constitutional limits to amend the remedy. So it's not a final word on the legislature can reconsider the statute as amended by reading in and make further amendments. Those are the principles. Now, to understand the reading in remedy, it's important to explain the drafting error, and that's what I attend to. Yesterday, in the context of the challenge to Section 19.8, you'll recall, I took the court to the judgment of the Constitutional Court in Hertfordshire. which held that Section 25 allowed expropriation to take place before the amount of compensation was decided by a court. And I took you to paragraphs 42 to 43 of that judgment. Initially, the expropriation bill followed that approach and allowed for the minister to make an offer to a right holder, and despite the right holder of disputing the amount, to proceed to issue the notice of expropriation, which then means expropriation takes effect. That was the scheme. And so it was in the context of that scheme that Section 19(2) and 3 used as the trigger event for the period for going to court to start running from the notice of expropriation. Because you would not have had to wait for the court to determine the amount. If it's in dispute, you would simply carry on with the expropriation by issuing the notice of expropriation. And so what Section 19(2) and 3 then provided for was, upon the issuing of a notice of expropriation, and expropriation takes effect, a person aggrieved by the compensation amount can approach a court within 180 days if they're acting personally, or if they want the expropriating authority to assist, they had 90 days to ask the expropriating authority to institute the proceedings. And in that 90 days, the expropriating authority had to start the work, and those proceedings would have to be instituted within 180 days. There's a fundamental principle of constitutional law which was upheld by the court in the judgment we handed up yesterday. Why you have 180 days, which is 6 months, similar to Paja, is because the person who is aggrieved by the offer to expropriate has to gather sufficient material, get legal advice, and prepare an application to court. So you need to afford sufficient time for them to be able to get into court in the 180 days. The judgment I'm referring to, we added in our bundle of authorities. I think we handed it up in loosely. It's Bruma versus Minister of Social Development. The court will find the relevant paragraphs is 53 and 56, but I'll give the court the context of that judgment and why it's relevant to the 180 days. You'll recall that previously the Promotion of Access to Information Act allowed a party to approach a court when your request for access was refused and your internal appeal was refused. But it provided for a period of 30 days to approach a court and not 60 days as in Paja. And in Broma, these were journalists, investigative journalists, asked for information from the Minister of Social Development. And he refused the access. They appealed, and the appeal was refused. They came to this court to get a court order access. One of the complaints was to challenge the 30-day period because they came to court after the lapse of the 30 days. And they argued that 30 days was not sufficient and breached their right of access to court by giving them limited time frame, and that the fact that the time could be condoned was not good enough. The period prior to condemnation must itself be sufficient to allow for access to court. I must say we won in the High Court here, and the Constitutional Court set that back and said that section in 53 and in paragraphs 53 and 56, 30 days was not sufficient because it didn't allow for sufficient time for a party to prepare their case to go to court, and the period must be 60 days comparable to Pacha as a guideline. So the reason I highlight this point up front is when I come to the content of the remedy, you'll recall that there was a suggestion. One of the alternatives is you can replace notice of expropriation with notice of intention to expropriate. If you do that, you will see that you cut down the time for the party to consider the offer, you cut down the time for mediation, eventually you cut down the 180 days, meaning that the result becomes unconstitutional. So that can't be a suitable remedy. So I'm just crossing that out at the upfront. But then what I need to take the court to then is It's just to show the court where the periods are afforded to the rights holder in the Act, and I don't need to take the court there. If you look at section 72H of the Expropriation Act, you will see that when a right holder receives a notice of intention to expropriate, I think the court wants to have a look at the section. I'm happy for that. So the section, you'll see the section in 7.2h, it's headed Notice of Intention to Expropriate. And I'm referring to the court to section 7, subsection 2, which says a notice of intention to expropriate must include under H, sub H, an invitation to any person who may be affected by the intended expropriation to lodge with the expropriating authority within 30 days after the publication of the said notice any objections to the intended expropriation, any submissions relating to the intended expropriation, a postal address, email address, or facsimile number for the expropriating authority to communicate with that person, and the preference of official language for further written communication. So if you use notice of intention to expropriate as the trigger event, they lose the 30 days. Or you take the 30 days off from the 180 days. So you already have a problem. And then if you look at section 19.1, you'll see that section 19.1, that's the section dealing with mediation and determination by court. 19.1 says if the expropriating authority and a disputing party do not agree on the amount, time, and manner of payment of compensation, they may attempt to settle the dispute by mediation, which must be initiated and finalized without undue delay by either party. So if you make notice of intention to expropriate the trigger event, you take away the time for mediation, or you take it from the 180 days. In either way, you're going to end up with less time afforded to a party to approach a court in the event of a dispute. So that alternative sounds very simple and very attractive. We all thought it was a solution until we looked at the scheme and realized the scheme values the interactive process between the expropriating authority and the right holder at the initial stage when there is a notice of intention to expropriate, before ultimately there's a dispute about the amount. It also values and builds in a mediation process, which allows for the resolution of the dispute around the amount. So the Act places a lot of value in amicable resolution of a dispute around the amount of compensation. And if you cut those things out, you defeat the scheme of the Act and the purpose that it seeks to achieve in that way. So when we get to our proposal, I will demonstrate why it retains that structure intact.
Mr. Mandeki,
Yes.
how is this mediation governed?
The mediation currently, all the Act says is it must be done promptly by either party. But Justice Saldana pointed out at the outset that these are details that may be regulated by rules. But in fact, the minister has powers to make regulations which he can make to regulate the time frames, because under regulation, let me just refer the court to the relevant regulation, regulation 26(1)b. It gives the minister the power by notice in the Gazette to make regulations regarding, under sub B, any ancillary or incidental administrative or procedural matter that may be necessary for the proper implementation or administration of the Act. So that is easily curable by the minister making regulations and saying, if there is a dispute, if a right holder disputes the amount of compensation and intends to go to mediation, they must do so within 30 days of them giving a statement saying they dispute, and the mediation must be completed within a particular time frame. And so that's the one problem that the DA raised, which can be solved by regulation. The second problem they raise is, but how do you know that the mediation has terminated? Well, mediation is consensual. So if one of the parties says we're withdrawing or the mediation is not fruitful, the mediation terminates, and usually those who conduct mediations know the mediator issues a report, a closing report saying the parties attempted mediation and mediation has failed. And then that triggers the ability for parties to go to court. Justice Saldanha and Justices is not a unique provision because under the Intergovernmental Framework Act, even under Section 40 of the Constitution, organs of state which are governed by Section 40 and are governed by the Intergovernmental Frameworks Act are not permitted to come to court when they are in dispute until they have attempted to resolve their matter through mediation. Generally, they get a facilitator to mediate, but that section doesn't say the mediation must start on this day and must end on that way, the mediation must be terminated in this way, because there is a general understanding of how mediations get terminated.
Mr. Manechi, it's not relevant for us, but the issue of cost has always been raised with regard to legal representation and litigation. Who pays for this mediation? Who pays for the mediation?
The section doesn't say, but maybe the minister can deal with that in regulations. But I would assume that in line with the spirit of Section 19.3, where if you're disputing and you want to go to court, you can ask the expropriating authority to be the one to assist, that the state would bear the burden where in appropriate circumstances to make the mediation facility available for the disputing party. So if it's an indigent person, for the state to facilitate the mediation, which would include payment for the venue, the mediator, and the like. Otherwise, that right would become nugatory because it wouldn't be capable of being facilitated. And our courts have spoken on this. In Magidingwani dealt with the right to legal representation in commissions of inquiry. And the Constitutional Court affirmed that in appropriate circumstances, the state must fund the representation before a commission of inquiry if that process is to be fair. So we submit with respect that those are things that can easily be addressed, and the constitutional standard we submit would require the state to assist and make that facility available. Against that, perhaps the one other section I must point out, it's section 7.4a Roman 3. Before I come to the act itself, to the proposed remedy itself, that section you will see. What did I say? 7.4a Roman 3. What did I do with the section? But that is the section which says, when a party disputes the amount of compensation. I've got some help. Thank you very much. 7.4 Roman 3 says, recall that you have 30 days to respond, but you've got the ability to ask for information and all of that from the expropriating authority. So what the section really shows you, and it goes back to the discussion of yesterday about investigation of the initial stages, is that it builds in an interactive process between the expropriating authority and the right holder for the gathering of information and for provision of particularity to a right holder. Then, having given you the opportunity to say whether you dispute or not, 4A Roman 3 says, a person responding to a notice contemplated in sub 1, that is the notice to expropriate, of intention to expropriate, within 30 days of the service or publication of the notice must, A Roman 1, state whether he or she accepts the offer, deliver to the expropriating authority a written statement. I wish the court could underline that written statement, because that's where the president had made a typing error or reference error in the initial proposed remedy in the answering affidavit, referring to a notice as opposed to a written statement and also referring to Roman 2 as opposed to Roman 3. But both the President and the legislature eyed them that the relevant provision is 4A Roman 3. A person responding to a notice contemplated in sub 1 within 30 days of the service or publication of the notice must A, deliver to the expropriating authority a written statement, Roman 1, stating whether he or she accepts the offer of compensation, Roman 2, requesting further particulars under section 14. As I mentioned, you can ask for particularity. Or Roman 3, disputing in terms of section 19 the amount of compensation offered. So your statement will say, I dispute the amount of compensation offered. When you've done that, you're either going to have a mediation or you're not going to have a mediation. If you have a mediation, it's only at the failure of mediation that you go to court. If you don't have mediation at all, if the parties decide we're not going to mediation, then you go to court immediately. So the proposed remedy must cater for that once you've given the statement, you can go to court provided you have chosen not to mediate. Or if you've chosen to mediate, the mediation has become unsuccessful. That's what the remedy must do. Then it keeps the scheme of the Act completely intact. And as our learned friends for Parliament are bold to say, it is a simple error, simple to understand and simple to correct. And so, and that is why in the heads of argument, AfriForum embraced our proposed remedy in the interim. I must emphasize, Mr. Havenka said in the interim. But he said it makes sense. And the minister didn't have qualms with it. It was the DA that persists in this opposition. Mr. Havenka did say in oral argument, no, he thinks it should be notice of intention to expropriate. I've shown why that can be a suitable remedy, clearly. Now, the remedy we propose with...
Sorry, just before you say that, I can't resist.
I beg your...
I can't resist. You say that your colleague says simple error, simple remedy.
Yes.
Why are we here?
No, meaning, no, for the court. We understand it should have been sorted out before
490 people
Yes.
didn't see the simple error.
Sometimes things become so obvious on reflection because we underline when we are preparing papers for court and we debate these things. Initially, it appeared to us that the DA is really smoking something, but we realized it isn't. It actually was right.
400 people were smoking something.
But I think for the credit of the executive at least, the president didn't beat about the bush. He looked at it and said, look, I think they made an error. And let's tell the court up front, we accept the error, and the error makes the act unworkable, and it must be fixed. And that's why we are making the submission. We accept the misgivings of the court, they are justified, but we are where we are. So the proposed remedy in our heads is quoted at paragraph 77 of the heads, of our heads. And we emphasize, supported by the legislature, by AfriForum, even though now grudgingly, but when they were writing the heads, they were right. And we say so we ask that the court, we propose a remedy involving the severance of the words.
Sorry, Mr. Manichi, give us the number again.
Paragraph 77 is page 32 of our main heads of argument, the longer heads. The heads for the president is page 32 of that.
Thank you.
Justice Slingers, I think, is still looking. I'll wait for the court to all be on the same page. So there are lots of paper. As it happens, trees die, and we tell you it's a legal issue.
Trees, forest has been laid
Forests,
to
yes.
waste.
Indeed.
Got it?
Yes. I think I'm still within 30 minutes when I finish this paragraph.
6. Got it, 6. That's volume 6.
If I had a blank page, I would hand it up, but I don't know if anybody has a blank page sorry, not blank page, unwritten page, and a clear page on that. I can tear out
It's found.
just swing us. Yes, thank you. So at paragraph 77, we underline the support by the legislature. It's important because you're worried about intrusion into the legislative space and separation of powers, and the legislature supports the proposed remedy, and the executive supports the only branch that must decide is the court. Otherwise, all the branches are agreed, or the branches of the state, so to speak. Supported the president's proposed a remedy involving the severance of the words of the notice of expropriation in section 19(2) and 3, and the reading in of the underlined words. And the underlined words would read like this. The section would read like this with the underlined words: if the expropriating authority and disputing party do not settle the dispute by consensus or mediation, either party within 180 days of the date, thus far that is how the section reads, when the mediation envisaged in section 9(1) is terminated without settling the dispute regarding the amount, time and manner of payment of compensation, or where no mediation is attempted as envisaged in section 19(1) of the date of receipt of the written statement in section 748 Roman 3, disputing the amount of compensation, institute proceedings. And is a similar textual change to subsection 3. There's nothing new in subsection that's added to subsection 3, is a repeat of that. So that we submit solves the problem and doesn't generate the problems the DA has submitted. I must say, and we say this with respect to our learned friend Ms. Pillay, she didn't then say of the 9 or 8 other alternatives, look at each one of them, they are also consistent with the scheme of the Act. They are suitable. We submit they are all not suitable because they cut down on the time frame. They create uncertainty in the scheme of the Act. But this stays true to the scheme of the Act, true to the purpose that the legislator wanted to achieve, and does less violence to the text of the statute. Less textual, well, it looks like many words and therefore there's a lot of surgery, but that surgery simply gives expression to what the legislature wanted to achieve. So it is perfectly in line with those guidelines. I'll pause here for questions, but otherwise these are our submissions in the 30 minutes plus 2 perhaps.
Do tell me why, when you're looking at 19.2
Yes.
and the first sentence, up until mediation, either party may, within 180 days, and if a comma was to be after 180 days, of the date of the notice of expropriation, and the comma there, if that's removed, does it bring you to the same position?
Let me hear what.
So all you do is you take out off the date of the notice of expropriation, institute proceedings in a competent court. So without adding any words.
So we take out. I just want to cross out.
Okay, just really, it's a midnight thought.
Yes, absolutely.
It's number 10 for Ms.
Yes.
So, within 180 days, comma, of the date of the notice of expropriation is removed, and then it continues institute proceedings. Why is there a
Yeah.
need
So
to-
it doesn't. Yeah, it may flow from one that's what you that must run from the end of mediation.
Well, it's not only mediation, because it says the parties do not settle the dispute by consensus
or mediation.
or mediation.
Either party may. Yeah. That also seems the midnight thought might.
Sorry, that's
But
all you're doing is that you're giving specificity.
Yeah, we are giving specificity.
And if you read it in context of one
Yeah.
and the previous sections that you referred to, is there a need to add any
Yes.
words in?
That might be the solution. So you simply strike out the offending words, and you solve the problem. Justice Salgana, that just shows why, although it's a simple error, it does take reflection to see it and resolve it. So for the 490 people,
Well,
this room also hasn't seen it until Justice Adana proposed it,
until the midnight clock.
until the midnight clock.
But is it necessary to add the words in? If it's sufficiently
If it works
made in
without
context.
the offending words, then it's not necessary. If it works without the offending words, it's not
Does it
necessary.
work without the offending words? I don't know.
If it doesn't work and leaves anything vague, then you need the specificity. So it's just, but either way, you're not cutting down on the 180 days, which is the principal issue
Yes.
that we want to retain, and you're not taking out time for consideration and time for mediation. If it works either way, either you have the specificity or you don't have the specificity, as long as it achieves that purpose, then it would be an appropriate remedy. And I'll leave it to my other more brighter.
Well, I just raised it.
Yes,
It's almost a wild thought at midnight,
yes,
but it simply removes the
take you
temptation to be accused
yes.
three lowly judges writing legislation.
Right, absolutely. That would be completely in line with the courts, because the court under section 1721A declares the section invalid to the extent of the inconsistency with the Constitution. And the inconsistency arises from those words. And if those are the offending words, those are declared invalid and so struck out from the statute, and that achieves the outcome, the constitutional outcome. So we would submit, if that works, that's the easiest surgery to perform. But I don't want to take any more time, court's time. I've had enough time. And those are our submissions. We ask that the 19.2 and 3 be declared invalid, as we've considered. Either a striking out or a striking out together with a reading in remedy be granted, and the rest of the constitutional challenges be dismissed. We don't ask for costs because of bywash, as the court pleases.
And if you're unsuccessful,
If we answer,
Yeah.
of course, then they get their costs.
All
Except
of
the amici. The amici doesn't get costs. It's coming here to assist the court. It's not in for costs, so it doesn't get costs. No risk, as the court pleases.
thank you, Mr. Maneki. Who goes next? Ms. Hoffmeyer. Thank you.
Thank you, Justices. If you could just give me a moment to arrange my
Certainly.
files. Thank you.
Good. Thank you, Ms. Hoffmeyer.
I'm indebted, Justice Saldanha and members of the court. Justices, I propose to deal with 5 topics in my address to the court today. They are the following: to deal first with jurisdiction, then to deal with the DA's mandates challenge, third, to deal with their challenge to the rules of the various provincial legislatures, The fourth topic will be to deal with sections 19.2 and 19.3. But with leave of the court, I propose that my learned junior, Mr. Kalala, deals with that aspect. And then I propose simply to return for the fifth topic, which is to say a few words about the prayers and costs. Justices, to frame my submissions for today, there are two principles to which I will return repeatedly in my submissions. The first is that pleadings matter. We know that the Constitutional Court in Garvis has said precision in pleadings is not pedantry. But as I will show this court on an issue of jurisdiction, it is not only not pedantry, it is dispositive. And the second important theme is that matters of jurisdiction are not technical. They are in fact matters of profound significance because they are about the competence of a court to weigh at all the merits of a case. So significant is jurisdiction that if a court lacks jurisdiction and nonetheless gives a judgment and order, our law says that is a nullity. There are very rare things in our law that are nullities, given the remedial powers that our Constitution gives courts. But the one thing that is a nullity, that the Supreme Court of Appeal confirmed in Motala remains a nullity, is any judgment and order given by a court that lacks jurisdiction. So when the DA says in its heads of argument that this issue is technical, it simply is not. It goes to the core competency of this court to entertain the DA's case at all. My learned friend for the DA, Ms. Pillay, said that the DA was almost surprised that the legislatures had taken this point, almost suggesting that it was somehow obstructive because part of the argument goes, this matter will go to the Constitutional Court in any event for confirmation. So why do we quibble now about the absence of jurisdiction of this court when any order of invalidity must go to the Constitutional Court, which has nationwide jurisdiction? The problem is that if this court lacks jurisdiction, then what goes for confirmation is a nullity. The Constitutional Court can't exercise any power over a nullity. So on the contrary, it's all the more important that this court properly weigh the question of jurisdiction. Because if it does not, and if it as a fact lacks jurisdiction, then what goes for confirmation is actually a nullity, and the Constitutional Court will be spending time on something that it actually as a matter of law cannot engage with at all. That's why we say it's significant and we say it's important, and I will show in the course of my argument, I hope, why this case doesn't get out of the jurisdictional starting blocks for the DA. Justices, there's another important overarching point about the background to this case. You would have seen in our heads of argument early on, we have a very long footnote. It's a footnote of all the recent litigation that the DA has been engaged in. I think in our heads of argument, we refer to it as a prolific litigator. I say that for a reason of importance in this case. And to use the words of the Constitutional Court, the one thing the DA is not is an indigent or bewildered litigant adrift on a sea of litigious uncertainty. It litigates often. It is now sitting in government. It makes choices when it litigates. And the choices the DA has made in this case, I hope to show, on every occasion is fatal to its case. The first is it chose when to launch this application. It chose to litigate before the Act took effect. It therefore chose to bring an abstract challenge before there was any impact of this law on anyone. That is an out-and-out choice that it made. The second choice is what to attack and how to attack it. It made a choice about whether it's going to run a public participation case that would have fallen within the exclusive jurisdiction of the Constitutional Court, or to try and run a different type of case. All of those are elections it makes before it launches. And the final election that it made was where to litigate. It's not forced anywhere. It's not vulnerable. It's not indigent. It chose to litigate in this court in circumstances where we will show this court lacked jurisdiction. And it must bear the brunt of those choices if all of them were made incorrectly, and the consequence of them is that it came to a court without jurisdiction to adjudicate the merits of its case. Justices, next I propose to deal with what I understand to be 4 uncontentious principles on jurisdiction that we say will guide this court's grappling with this issue. The first is that any case about a failure of public participation in the legislative process is a case that falls within the Constitutional Court's exclusive jurisdiction. My learned friend Ms. Pillay correctly, with respect, accepted that in her oral address. That case can't come here. The DA recognizes it. It's at pains to say that is not its case. What I will say in due course when we get to the merits of my argument is that that was a fatal error because the consequence of it is they have no constitutional hook for their mandates challenge. But I'll develop that in due course. But the important point is, from jurisdictional principles, if this case is about public participation in the legislative process at all, everyone agrees this court doesn't have jurisdiction over that. Second important point is, what jurisdiction does this court then have? This court has a territorially bound jurisdiction. And it's a territorially bound jurisdiction because the Constitution says it is territorially bound. You would have seen in our heads of argument the reference to section 169(2) of the Constitution. The Constitution says the High Courts consists of divisions determined by an Act of Parliament, which assigns jurisdiction to a division or a seat of a division. The backdrop to that is territorially bound divisions. And flowing from that, we have to look at the Superior Courts Act and Section 21. Again, I understand the position with the DA and us to be utterly common cause on this. Ms. Pillay, my learned friend on Monday, says they recognize they have to fall within Section 21 of the Superior Courts Act. And she also recognized that that requires one of 2 bases of jurisdiction to be established for their case, either residence or cause arising. Those are the 2 options for the territorial jurisdiction of this court, and I will endeavor to show in due course neither is met. Justices, the third important principle is one that we reference. I don't suggest you go there, but just to give you the hook for it at paragraph 28 of our heads. It's that point about pleading and jurisdiction and what the Constitutional Court has said about it in Harbour. What the Constitutional Court said there is the following. In the event that jurisdiction is challenged, the applicant's pleadings are the determining factor. They contain the legal basis of the claim under which the applicant has chosen to invoke the court's competence. And that was reaffirmed in the more recent decision of the Constitutional Court in the Zuma case involving the special leave of Minister Poon. There, the pleaded case for jurisdiction comprised 2 paragraphs. The Constitutional Court went there and found that that pleaded case was inadequate to invoke its jurisdiction, and it found that it lacked jurisdiction to entertain that case. So the emphasis on that point is that the Constitutional Court has remained firm to that guidance in Harbour. There are other circumstances where the court is more accommodating of deficiencies in pleadings, but on jurisdiction, you go to the pleadings, you see the case that the applicant has elected to make for the court's jurisdiction, and in the words of the Constitutional Court, that will be the determining factor. And justices, the final and fourth point governing, which I also take to be common cause, is the point I made earlier. Absence of jurisdiction renders a judgment and order a nullity. So much so that our courts have held that an appellate court can mera motu raise an absence of jurisdiction and the concomitant nullity of the court of first instance judgment. Just a reference for that proposition is the case of the wave dancer. It's an appellate division decision, 1996, 4 South African law reports, 1167 at 1173J to 1174D. Justices, that's the background and framing to the argument on jurisdiction today. From those 4 principles emerges what I submit is the first problem for the DA. And that problem relates to 2 new arguments for jurisdiction that we heard in the course of this week. The first is an argument about submission and consent to jurisdiction, and the second is an argument about the impact of the transfer of the AfriForum case for this case's deficiencies in jurisdiction. Justices, those 2 new arguments can be dispensed with in one breath because they are not pleaded grounds of jurisdiction anywhere in the DA's papers. There was an opportunity for the DA to make either of these cases in its papers. The reason I say that is because the answering affidavit of every one of the legislatures for whom I hold a brief today took jurisdiction fairly and squarely. To make out a pleaded case for submission as a basis of jurisdiction or transfer as a basis of jurisdiction, the DA had to plead that somewhere in its papers. It did not. The consequence of that...
Let's get the time
Yes.
right. So when the replying affidavits are made, had there been a consolidation at that stage?
Justice Sodon, I'm indebted for the question for 2 reasons, in fact. The language of consolidation was used yesterday when this issue of what the transfer meant was used. There was no consolidation. That's quite an important point for an argument I'll come to in a moment. It is merely that these 3 cases are being jointly heard today. Consolidation has a much greater significance. Evidence in the one case is none of that has happened. All that happened is we've got 3 cases for convenience jointly heard this week in this court. But to get the timeline right, if I may, because again the timeline is going to be important. What happens is the DA launches in February of 2025. The order of transfer occurs on the 5th of May 2025. No answering affidavits are in, so no one's seen the jurisdiction point being taken yet. No one in any case. All we have at the point in time that the Gauteng court gives the transfer order is the founding papers of the DA. And with great respect to my learned friend, Mr. Maineche, who acts for the president, he began yesterday to say, in that case, in the answer, we said in a throwaway line for the president, this court has jurisdiction. But he says, with the greatest of respect, that was an error of law. We hadn't seen the position yet, but no court is bound by that concession based on an error of law. So the first time anyone knows that jurisdiction is a pivotal issue in this case is September 2025, when the legislatures on 7 occasions in 7 affidavits take that point. Now, what it was open to the DA to do is when it replied, say something about submission. Say, hang on, we've got an abiding Minister of Public Works, and that abiding amounts to a submission. They have to plead it. They have to say that so that anyone else who wants to say something about that submission has a fair opportunity to do so. They do nothing. What I will actually take the court to in a moment is show you how they read the DA's minister's affidavit in exactly the same way as the legislatures read it, which is that it is nothing close to a submission. That's why they didn't take the point. There's no submission in that affidavit. Right. They also know the transfers happened. So if they wanted to cleave for themselves any life for their jurisdictional woes out of the transfer, the reply is the point to do it. Say, we've seen the complaints about jurisdiction, but we get the benefit somehow of the transfer of the AfriForum case to be heard jointly with our case, because we can reach into it, take its jurisdiction, and vest this court in our case with jurisdiction. Justices, I'll take you to the Supreme Court of Appeal decision that says that is not competent as a matter of law at all. But I'm now in the point of my argument where all I'm dealing with is pleadings. Haber says jurisdiction will be determined on the pleadings. Both of these new arguments can be dispensed with in one brushstroke. There is no pleaded case for submission or transfer by the DA. Justices, despite the fact that that should be the end of the matter, I will not be doing my duty if I do not effectively plead over in argument. If, despite the deficiencies on pleadings, this court were inclined to entertain the question whether there has been a submission to jurisdiction and whether the transfer is adequate to vest this court with jurisdiction where it is otherwise lacking, I have the following submissions to make. Justices, the argument of submission from the DA takes two forms. I understand part of it to be there's something about the Minister of Public Works' affidavit, answering affidavit, before the one we got yesterday. There's something about that answering affidavit which constitutes a submission. But Justices, I said I would go there, and I'd like to take the court to it now, if I may. That answering affidavit is replied to by the DA, and it's actually the reply I'd like to take the court to. And you will find the reply and the pertinent part of it at 010-12 in the DA case.
You said 10 what?
12. So 10-12. It's the internal 7th page of Minister McPherson, at least the DA's reply to the answering affidavit of Minister McPherson. Justices, my point is already...
Give us a second, please.
Of course.
Which paragraph?
It's paragraph 16, Justice Harntooth Lockwood. I'm wanting to go there because of a point I made earlier. Apologies, I see Justice Saldana is still with us.
Yeah.
And it's paragraph 16 on page 1012. Justices, I've made the point earlier, you will search in vain in this replying affidavit for any allegation that the Minister for Public Works' affidavit constitutes a submission. But what I'm going to now is to explain to you why that wasn't even available to the DA. Because the DA correctly characterizes the Minister's affidavit in paragraph 16. They say the Minister's affidavit concerns only remedy. He does not engage with or address the substance of the DA's case. Absolutely right. Minister McPherson's affidavit is a conditional one. He says, I am abiding. I am not weighing in on the merits at all. But what I am going to do is, if the court gets to remedy, if the court finds on the merits for the DA, then I have a few things to say about remedy. That can never be a submission. It's a conditional, explanatory affidavit that if the court gets far down the road of its merits adjudication, then Minister McPherson has a few things to say. So it is simply not only not pleaded, but not available to the DA, we submit, to construe Minister McPherson's explanatory affidavit as a submission. So that brings me to the second leg of the argument for submission that relies on the affidavit that was purported to be placed before the court yesterday. Justices, I understand from my learned friend Mr. Katz, he does intend to move for the admission of that affidavit. I indicated to him when he asked me about my approach that I would deal with it in my main argument. And so with your leave, I would like to give the court the legislature's position on the receipt of that affidavit and its contents. Justices, the legislature's position is the following. That affidavit should not be admitted. It should not be admitted for two reasons. It has no probative value whatsoever, and it, as a matter of law, is legally irrelevant. And I'll deal with each of those in turn. It has no probative value whatever because of three features of it. And Justices, if I may request that you pull up the affidavit, because it's very important to see precisely how Minister McPherson says what he says. Justices, I commence at paragraph 3 of that affidavit. Minister McPherson says at paragraph 3, I confirm that I consent to jurisdiction of this honourable court in all three applications. Paragraph 6 over the page. I believed and still believe that this court has jurisdiction with or without my formal consent. My belief is entirely consistent with the legal advice that I have received. And then finally over the page at paragraph 9, I was and remain of the view that a constitutional challenge to national legislation, abstract or otherwise, may be brought in any division of the High Court in South Africa. Justices, there was a point with respect that Justice Saldana made to my learned friend Mr. Katz when we had a debate about this. I think it was on Tuesday after 4 o'clock. Monday afternoon. It was the following. Minister McPherson's personal views about, well, Justice Saldana, this is not quite the way you put the point with respect, but your point was there might have been a political call made by Minister McPherson at a point in this case. The significance of that point for the argument I'm about to make is that Minister McPherson's personal views on any of these aspects is entirely irrelevant for a very important reason of constitutional significance. Minister McPherson is only in this case because he is the representative of national government. Our case law back decades has said when legislation is challenged for constitutional inconsistency, there must be a representative of government. The courts have described it as follows. The striking down of an act of parliament affects a matter which is vital to the interests of the central government, and the appropriate official must be the responsible minister. The government must be represented by the appropriate authority, and that authority would be the responsible minister. Minister McPherson's only status in this court is to speak for national government. But, Justices, the first problem with Minister McPherson's new affidavit readily reveals itself when that point is identified. Minister McPherson doesn't say he speaks for national government, doesn't say he has squared his consent to the jurisdiction of this court with national government, and worse still, this court knows the head of the executive does not consent to the jurisdiction of this court. So quite what authority Minister McPherson purported to place this affidavit before this court remains a question. Nowhere in that affidavit does Minister McPherson say, I am speaking for national government, and national government, which is the only voice with which I may speak in this case, consents to the jurisdiction of the court. And that is why we say it has no probative value as a matter of law or evidence, because the only voice with which Minister McPherson may speak is as representative of national government. It does not matter what his views on jurisdiction are. It doesn't matter if he thinks it would be a good idea that this court can hear more cases. It matters not at all as a matter of law. And Justices, the second point is even if it did constitute consent of the national government to this court assuming jurisdiction in this case, that would be inadequate as a matter of law. And the reason for that is the Appellate Division's decision in Venetia Mineraria. And Justices, that is a case I would like to share with the court. It's part of a supplementary bundle. We shared this with our colleagues yesterday. But it's so dispositive of this point that I'd like to be able to just hand up copies, if I may.
Since we're in the sharing mode,
Yes.
Mr. Katz referred to a case he
Yes.
provided you with
Yes.
regards to whether he needed
The affidavit.
to make an affidavit other than the assertion or the
Yes.
declaration on Monday morning, Minister consents to
Yes.
the jurisdiction. He said that was not even necessary for them to reduce to an affidavit. But that was the declaration made. He says the affidavit is unnecessary on his advice to the minister, but he did the affidavit because he thought it was necessary. So, the case he referred to, has that been shared with the court?
It has certainly been shared with me. I do not know if it has been shared
No.
with the court.
Mr. Katz, there are no secrets in this process.
No.
If you have a case that you think is helpful to this court to arrive at a decision and issues which are being debated, then as a matter of courtesy, you ought to have shared that decision with the court.
Yes, it's in paragraph 12 of that there.
Where is the case?
Justice Poe, it's in
Have you handed it up?
I haven't.
Why not?
Yes, we'll give you a copy in a second because I wasn't allowed to. I wasn't allowed to give you a copy, or I wasn't allowed to speak to the issue.
Excuse me, you handed up an affidavit with a notice of motion. You
Yes.
said you had shared the case with your colleague.
Yes,
Why
I
could you
shared
not
it.
share it with the court?
No, the point is, when I moved for the application, I certainly I'm not in a position to do that until I moved for it, and I had an arrangement with my learned friends that I wouldn't move for it until she's finished her argument. When I get a chance to move for it, I'll certainly hand it. I haven't had a chance to move for my
You had your absolute chance to provide the court with a copy of the judgment. That's the point I make, Mr. Katz. We're under tight time constraints in this matter. We have to read a number of documents that are handed up to us.
Yes, then I apologize, but I have not had an opportunity.
It's tea time now. Please make sure that you sent it up to the court.
I'll do it.
Thank you.
I'll do the next one.
Please proceed.
Just, I just want to make sure, I don't want to fall foul. Is this the judgment that is referred to in paragraph 12 of the affidavit?
You referred to the judgment that you handed to your colleague and said it's not necessary for us to go on affidavit. Provide the judgment to the court.
As it is. So,
Thank you. Sorry about that.
Not at all. I realize we are at tea time.
Are
And
we at tea
if it is an appropriate point to pause, because hopefully over the tea break, the justices will be furnished with the case, and then I can address it to the extent the court wishes me to do so.
Thank you. We adjourn for tea. Thank you, Ms. Hoffman.
I'm indebted to justices. Justices, I am in a position to deal with the case, but I would like to just check that the court has been furnished with it before I do so.
Is that ugly grip?
Indeed.
We've just received it as we walk in, but please proceed.
Thank you, Justice Saldana. Our primary submission is that the relevance of the case has disappeared, first and foremost pursuant to the production of an affidavit, because, as I understand Mr. Katz, he was going to seek to rely on this case for the proposition that he didn't need to supply an affidavit. And notwithstanding that point taken 2 days ago, we now have an affidavit. And you've heard me on why that affidavit either shouldn't be admitted or, if admitted, has no probative value nor legal relevance. But to the extent that my learned friend will want to say anything about this case, I think it is incumbent upon me to give you the legislature's attitude to its relevance. Justices, it's a case bound by its facts, as so many cases are. It's a case about an urgent interim interdict to confirm jurisdiction by means of attachment and seizure of 200,000 rand in the bank account of the respondents. Just to emphasize a few things, it's a case about confirming jurisdiction, not founding jurisdiction. So the court already has jurisdiction, but they need personal jurisdiction over the peregrinous defendant. And so the way to do that is the applicant goes to court with an interim urgent application to attach property of that defendant in order to confirm jurisdiction. And in that context of urgent proceedings, the respondent says, please don't attach my bank account, I consent to jurisdiction. In that context, counsel's submission from the bar that his client consented to jurisdiction to avoid the attachment, which is a recognized basis of consent to avoid precisely the attachment that was sought, was said to be adequate. There was no reason to doubt that counsel was telling the court what he was authorized to tell the court, and they were in urgent proceedings. And that was the basis for saying consent was enough, and they didn't have to delay the urgent proceedings to obtain an affidavit to that effect. Justices, that case is so far removed from our current case that no reliance, analogous or otherwise, can be placed on it. The reason for that is our facts. This is not an urgent application. The issue of jurisdiction has been on the papers for 11 months. That was more than enough time for Minister McPherson, should he have wanted to do so, to go on affidavit to consent to the jurisdiction of this court. But more importantly than that, the reason why the affidavit is utterly essential in this case, and why I began on Monday morning saying the legislature's position would be we need that affidavit, is because the legislatures knew they had the head of the executive in court saying there was no consent. In that factual circumstance, if a minister in cabinet wants to come to consent as representative of national government to the jurisdiction of this court, it must be done on affidavit. And as I've already addressed the court, it needs to speak for national government to have any legal weight at all. It does not, for all the reasons I've given already to the court. Justices, that dispenses with the case. I was at the point in my argument before the break where I was going to take the court to the Venetia Mineraria decision, because that decision says that even if Minister McPherson could get over all of these problems of representativity of national government, and the court could take cognizance of his beliefs about the legal position and his eagerness to consent, there is a legal bar to that consent having any legally efficacious consequence in the case. And that is what the appellate division said in Venetia Mineraria. Justices, it's a judgment of 1987 of the appellate division. You'll find it from page 1 of the supplementary bundle that we've shared with the court. The relevant paragraph comes right at the end, but the judgments leading to it is a vast and comprehensive analysis of submission, when it's recognized, when it's not in our courts. But the upshot of it is on page 5 of the bundle I've handed to to the court, at reported page 894, and it's the second line, the second sentence there. The court there says, by prorogation, that is submission, a defendant subjects his person to the jurisdiction of the court. But that is not enough. One or more of the traditional grounds of jurisdiction must also be present. So submission is only legally efficacious if it adds to an existing traditional ground of jurisdiction. And justices, that point has been made very eloquently with respect in a very recent judgment, which is the third judgment in the pack that we've handed up. It's a recent judgment of April this year of the Northwest Division of the High Court at page 11 of the bundle I've handed up. And with all due respect to the acting Justice Wessels, I don't think it could be said better, than it is expressed at paragraph 18 and 19 of that judgment. 18 and 19 are an articulation of what Venetia Mineraria in fact means. And at paragraph 18, you'll find that at paginated page 12 of the bundle. The court says the following: it is trite that parties may consent to the jurisdiction of a court that would otherwise lack jurisdiction, provided that the court is competent to exercise jurisdiction over the subject matter of the dispute. However, where a court lacks inherent jurisdiction over the subject matter, consent cannot confer jurisdiction. Then there's the quote from Venetia Mineraria, and then at paragraph 19, that's actually an earlier quote from Venetia Mineraria, referring to Ueckermann versus Feinstein, on which the AD placed reliance. And then at 19, the summary: the principle is clear. Consent to jurisdiction, whether express or implied, cannot cure the absence of traditional grounds of jurisdiction. And justices, you would have seen from our heads of argument, something like 40 pages of them are devoted to why this court has no traditional ground of jurisdiction in the DA's case. If that is so, submission can't cure the problem. And so that is the final reason why the affidavit shouldn't come in, why submission isn't an issue in this case or shouldn't be. It's simply that it's legally irrelevant in a case in which there is no, quote, traditional ground of jurisdiction, which it supplements. Justices, the same can be said of transfer. And I propose to deal with transfer swiftly. It's the second new ground of jurisdiction that was advanced by the DA in its submissions on Monday. My first argument there is the one I've made already. Nowhere is transfer a pleaded basis for jurisdiction in this case. That is enough on Kaba for this court to ignore it. But to the extent that the court wants to grapple at all with transfer, the simple answer on transfer is it's a worse case than submission. If submission can't vest a court that lacks a traditional ground of jurisdiction with jurisdiction, then transfer of another case, simply to be heard jointly with this case in the same week before this court, can't cure the jurisdictional deficits in the DA's case. And on that, there is also a Supreme Court of Appeal authority to which I'd like to draw the court's attention. Justices, it's the Leibovitz decision, and it's in our supplementary bundle at page 15. It commences at 15. The relevant proposition of law in a judgment of Justice Jafta when he sat on the Supreme Court of Appeal appears at paragraph 8 on page 16. Justices, it's the third sentence, but starting at the end of the second line, that I'd like to draw the court's attention to. It is to the following effect. Paragraph 8. The fact that a court has jurisdiction in respect of certain legal proceedings does not confer jurisdiction on such a court in respect of other legal proceedings. That is a case involving a single set of proceedings against differently situated respondents. And notwithstanding that proximity, the ratio of the Supreme Court of Appeal is you can't use jurisdiction in one case to imbue another case with jurisdiction when it is lacking. We say this is an a fortiori instance of that. It's not even in the same case. What the DA now wants to do is to breathe life into its case by saying, well, you happen to be dealing with another case in which we are not a party, but in respect of which, if you have jurisdiction, we get the benefit of it. That is not our law. Our law does not permit that, and there's a simple reason why. Jurisdiction is all about election. It's the point I started with in my submissions today. litigants like the DA choose when to litigate, what to litigate, and where to litigate. When they choose this court, they must give this court, in their founding papers, the basis for jurisdiction. And Justices, that takes me finally to the pleaded case. Because that pleaded case, what we've dispensed with already is the unpleaded case, the submission case, the transfer case. The pleaded case for jurisdiction lives in one paragraph in the founding affidavit. And that is paragraph 89. And I wish to take the court to it because I will keep referring back to it. Justices, I'm aware in making this part of my argument that we deal with this in a great level of detail in our heads of argument. And in the interest of time, I don't propose to detain the court there much. What I rather propose to do is to pick up on some of the points made in the oral submissions of my learned friend, Ms. Pillay, so that I can bring home any concerns the court might have about the arguments we've already made in our heads of argument on jurisdiction. Justices, you'll find that paragraph in the founding affidavit at page 002-31, and it's paragraph 89. Justices, paragraph 89 is the jurisdictional work in the applicant's founding affidavit. It is 5 lines long. It has 3 propositions. And before I go there, it's useful just to recall that this case has 2 causes of action. There's the mandates challenge, and there is the Section 19 challenge. So what the court is looking for in 89 is the jurisdictional basis for each of those claims. The first one is the one that grounds the mandates challenge jurisdiction on the DA's version. I will endeavor to show the court in my argument why it doesn't get them home, but it is the one that attaches itself to the mandates case. And let's read it. First, the matter concerns the NCOP, which sits in Cape Town. Justices, that is, with respect, an unhelpfully vague statement. It concerns the NCOP, which sits in Cape Town. But the problem, with respect, Justice Saldana, with that being a basis for jurisdiction, is a point you made to my learned friend on Monday. When she was in the argument on mandates, there was a point at which, Justice Saldana, you said to my learned friend, but the DA didn't challenge the vote in the NCOP. The DA has not challenged that conduct. That is conduct, the votes in the NCOP that took place. That is conduct that happened in Cape Town. We will say there's no constitutional hook for that when I get to the merits, but at least that is something that happened within the jurisdiction of this court. But there is no challenge to what happened in the NCOP before this court. What there is challenges to conduct in 5 provincial legislatures beyond the territorial reach of this court. 5 provincial legislatures. Again, to go back to the point of election, if the DA had just chosen to bring this case in Pretoria, none of these arguments would be available to any of the respondents, because the Gauteng legislature was one of the impugned legislatures, and Gauteng is where the principal place of administration of the minister is, the national representative. But they did not do that. They brought the case here for a mandates challenge in a situation where they don't attack what happened in the NCOP. So that puts them out of court on any jurisdictional basis for their mandates case. And the DA is actually perfectly aware of this problem for their case. It's a point we made in our heads of argument at paragraph 34.3. Justices, you'll find that at page 018-93 of our heads of argument at paragraph 34.3. Justices, that is where the DA, in its own words, in its own heads of argument, is summarizing for the court what the mandates challenge is all about. And we've quoted it there for the court. In the words of the DA, the following is said: the mandates challenge impugns decisions by provincial legislatures to confer final mandates lawfully. And then the important sentence: provincial legislatures are not synonymous with Parliament. Indeed, we agree. That's why if your case is about the provincial legislatures, you've got to follow one of them for jurisdictional purposes. Not 5 of them. We've made this point in our heads of argument. It is not our case that you have to launch 5 separate cases. You just find a court with jurisdiction over one of the provincial legislatures. But not even that did the DA do. So there is no jurisdictional basis for the mandates case. Justices, that makes us return, if we may, to paragraph 89, because paragraph 89 now has 2 further bases for jurisdiction. The second is the Expropriation Act is of national application, so the cause of action regarding Section 19 also arises in this court's territorial jurisdiction. Justices, I must stop myself because there is one point that was made by Ms. Pillay on the mandates case jurisdiction that I haven't gone to, and I'd like an opportunity just to dispense with that. In the heads of argument and in the address on Monday, there seems to have been an effort to massage to some extent the jurisdictional basis in that one sentence in paragraph 89 that the case concerns the NCOP. It becomes an argument, and my learned friend will correct me if I'm wrong in this, that tries to talk about the fact that the mandates were implemented in the NCOP, which sits here, and that's enough to create a jurisdictional basis. And for that argument, they rely on the Norkia case of this court. It's a judgment of Acting Justice Cockrell. And that judgment refers to a State Agents Board v. Leck. The upshot of all of those cases on which the DA places reliance is the following notion. You sometimes have situations where the applicant before the court is on the receiving end of unlawful conduct that is in breach of the principle of legality. In Estate Agents Board, it's an estate agent wanting to trade and work in Cape Town who can't get a Fidelity Fund certificate out of the Estate Agents Board that sits in Pretoria. Norkia, the facts are a self-represented applicant who had applied for funding from the IDC. The IDC rejected his application for funding, so in an effort to right that wrong, Norkia approaches the public protector, asks the public protector to investigate. The public protector investigates, finds against any wrongdoing on the part of the IDC. And so Norkia comes to this court and says, I want to challenge that decision. In those contexts, this court, twice, because Leck is also a case from this court and Norkia is following it, says when you have a legality challenge like that, where the impact of the legality challenge on the applicant occurs within the jurisdiction of this court, then that could be a basis for jurisdiction. The problem for the DA with the reliance on this aspect is that they don't claim any effect on the DA, the applicant. They say something happened in the NCOP. But to return with respect to Justice Saldana's point on Monday, no challenge to the vote in the NCOP. And despite that, they seek reliance on cases that just fall in a different category. Those are cases when the applicant says, I've been affected in my ability to trade or my ability to get a loan within the jurisdiction of this court, and that should be enough to vest this court with jurisdiction. Those are not analogous cases for this mandates challenge. And justices, with that just dispense with, if I can go to the second basis. Justices, the National Act basis, I didn't actually hear much by way of argument from my learned friend Ms. Pillay on Monday. So I hope to deal with it briefly and then deal with the Minister's office, because she did spend some time on the Minister's office. The short answer on the National Act being a sufficient basis is really what the DA says in its own following paragraph of the founding affidavit after paragraph 89. Paragraph 90 is the undoing with respect of this ground of jurisdiction, because 89 says the Expropriation Act is of national application, so the cause of action regarding Section 19 arises in this court's territorial jurisdiction. But then they go on to explain, as they must in paragraph 90, this application, in respect of that challenge to 19.2 and 3, does not rest on any factual matrix. It is not the case that someone has been impacted yet by the absurd limitation period in 19.2 and 3. And I think they meant to say, and it has grave constitutional implications. So in the same moment that they say their cause of action basis is the Expropriation Act and its impact, they recognize they chose to launch this case as an abstract challenge before there had been any effect on anyone. And justices, the reason why that undoes their second ground of jurisdiction is because you heard from my learned friend Ms. Pillay, but lots of cases of constitutional invalidity begin in this court and end up being confirmed by the Constitutional Court. So how can it be that this court can't have jurisdiction when it's had jurisdiction in many other cases? Justices, my faithful team of juniors went to search for a smattering of those cases so we could check ourselves on this. All of those cases, and I'll give you 3 just illustratively, are cases where the impact of the legislation is experienced by someone within the territorial limits of this court. Let's take the Musa decision. It's a challenge to the Wills Act. The impact was on property of the surviving spouse of a Muslim rights marriage in the jurisdiction of this court. That is obviously a sufficient cause arising to vest this court with jurisdiction to grant the invalidity declaration to go up for confirmation by this Constitutional Court. Justices, just to give you the reference to the case, 2018, 5, South African Law Reports, 13. Judgment of the Constitutional Court. The next example is Prince, Drugs and Medicines Act challenge. Mr. Prince had smoked cannabis. That he was convicted. The consequence of that meant he couldn't get registered with the Western Cape Law Society to practice as an attorney in the Western Cape. Comes here, gets his declaration of invalidity, it goes up to the Con Court. 2018, 6 South African Law Reports,
No, in fact, he lost.
393.
He
Yes,
lost.
yes, he did, indeed. And this was on appeal, yes, that it gets reversed.
No, in fact, it's tight on appeal.
Indeed,
6-7.
Indeed.
He still loses.
he does. He
He had to come back many years later.
He does. This one, I
This
think,
is
is
the
the
first
one where he wins, 2018.
It's the second.
Yes, it's the second, yes.
The only reason I remember the matter because he unceremoniously fired me as attorney.
So it's distant but possibly difficult memories, Justice. 2018, 6 South African Law Reports, 393 Constitutional Court. Justices, I can go on. The point has been made. All of those cases, there's a cause arising basis for jurisdiction because that act has taken effect. It's implicated someone in their fundamental rights to trade, to associate. And on that basis, this court rightly exercises jurisdiction and it goes up for confirmation. But absent jurisdiction, that judgment will be a nullity and there will be nothing for the Constitutional Court to confirm. And so the final aspect on jurisdiction.
Software.
Justice O'Donnell.
The reality is that there are members of the applicant in the Western Cape. And they might have to access the Expropriation Act. So that's sufficient.
Yes, if they had said that in paragraph 89. But they do not say that in paragraph 89, and they can't say that yet because the Act has not taken effect.
Except they bring the application in terms of the wide standing
Yes.
under the Constitution. It's in their own name, in the public interest, and on behalf of their members. They say so.
Justice Saldana, standing is discrete from jurisdiction.
Yes.
And the reason why jurisdiction and pleadings matter is that if the DA in paragraph 89 had said, we bring this in the interest of our members who are resident in the Western Cape and who stand to be affected by this act, that is a different jurisdictional basis on which this court would have to give consideration. And part of the questions this court would ask itself, amongst others, is do we entertain an abstract challenge of that nature prior to implementation or not? We know abstract challenges have a higher hurdle. There's an interest of justice challenge. So a range of different factors would come into play had that been the jurisdictional basis. It was not, and not even that basis was offered in reply. Despite saying that pleadings matter, I'm not a pedant. If they'd come in reply, seen the case on jurisdiction and said, hang on, but members are located here and members are enough and members stand potentially in due course to be affected by this act and we can get over the abstract challenge problem, that is a ground of jurisdiction. They don't do it in their founding papers. They don't do it in reply. So that, we say, is a reason on the pleaded case for jurisdiction, which is all about their election and what they choose to ground as this court's competency, a reason that they are still out of court. Justice Saldana and Justices, the final ground is the Minister's office in Cape Town. This one can be dispensed with very quickly because even the judgment of Johnson, to which my learned friend Ms. Pillay referred and placed some reliance on Monday, is not a judgment for this ground of jurisdiction being this purported ground of jurisdiction being adequate. Johnson, at best for the DA, is a case in which the court accepted on the evidence that the minister had a principal place of administration within the court's jurisdiction. Why was that? Because that was the common cause facts in Johnson. But not even that gets the DA out of its difficulties, because its pleaded basis is not that the minister has a principal place of administration in Cape Town. It is that the minister has an office in Cape Town. And justices, an office in Cape Town has not, to my knowledge, ever been a recognized ground for jurisdiction. The case, as pleaded, gets worse for the DA with respect because the legislature squarely took this point. In their argument for the lack of territorial jurisdiction, justices, you'll see this in our heads of argument at paragraph 36.1. At page 018-97. We reference there the paragraphs in both the Speaker's and the NCOP's answering affidavits in which the point is made that the seat of government is in Pretoria. Seat is another way of describing principal place of administration. There is no denial of that fact in the replying affidavit of the DA. So the only ground of jurisdiction that even in the Johnson decision was recognized as adequate is a principal place of administration of a functionary of state within the court's jurisdiction. Clearly contested by the legislatures in their affidavit, Cape Town is not a principal place of administration. that is in Pretoria, Gauteng, and no dispute of that by the DA in reply. So the common cause evidence before this court, again, pleadings matter, is that the principal place of administration is Gauteng, no counter to that on the evidence by the DA, the only asserted basis is office, and no law of which I'm aware that says office is adequate.
The Minister says
Yes.
court may take judicial notice.
Yes. Is that Minister McPherson?
Yes.
Yes, no, I recognize that. That is not an issue of which the court can take judicial notice when the facts are against that proposition. The facts are not so. The National Assembly, as stated before this court, and the National Council of Provinces chairperson, that the seat of the administration of the national government is in Pretoria. It is incumbent upon an applicant wishing to dispute that as being the common cause fact in this case to dispute it. What a court cannot do is, by judicial notice, subvert a common cause fact on the evidence. And if I can explain with reference to the Mfwethu decision, which we have referenced in some detail in our heads of argument, the question of what is the principal place of administration is actually not always a simple question. What Justice Rogers did in that case is he made it clear the fact that there it was a juristic person, but our common law relies on the ratio of juristic persons' residence for extrapolation to government and quasi-legislative bodies. So the principle is the same. What Rogers does there is he says, Justice Rogers does there is he says that you have a place of business within the jurisdiction of the court, or even a principal place of business within the jurisdiction of the court, doesn't mean it is your principal place of business within the Republic. And residence requires the applicant to go after the respondent in the principal place of business in the Republic. Those are our common law rules of jurisdiction. It's another point we made in our heads of argument. The one thing that the DA doesn't do is ask for any development of those traditional grounds. That's another case they might have brought had they been minded to do so, but they don't. So what you're left with is actually principal place of administration on the facts is not axiomatic. If you're asking the right question, as Justice Rogers said in Mfwethu, you need to ask to answer this question. You are asking, what is the principal meaning singularly main place of administration within the Republic? And what you have on the evidence before you is the NCOP and the National Assembly saying that's Pretoria, and no counter to that by the DA.
The Minister says we take judicial notice that he has two principal places of business, Cape Town and Tshwane.
Yes.
That's what he says. He says, courts, you can take judicial notice.
Yes.
I've got two principal places of business.
Yes. Justice Aldana, if that is in the affidavit that, yes, Justice Aldana, our answer to that is threefold. The first is the affidavit is not before this court. It certainly has not been an opportunity to be answered by anyone. And for all the reasons I've given, it has no probative value because it is an affidavit purporting to speak for national government and does not do so. Even the submission that there are two principal places of business has significant ramifications for every case post this case. Minister McPherson stating to this court that he has two principal places of business means, if it is the foundation on which this court finds jurisdiction, that in every subsequent case, the national government will face litigation as much in Cape Town as in Pretoria. Now, on the facts before this court, that would be, with respect, a very bold step to take, because we know that the president has not come on oath to say that that is how cabinet functions. We know that no part of this, the evidence of the National Assembly and the NCOP on that issue is disputed. We have a minister saying the court can take some judicial notice of the fact that he sometimes works here and sometimes works there. It is a question based on fact whether even an assertion to that effect is so, and if he were to do so, our submission would be many more facts would have to be brought to bear and explained as being the basis why, and they'd also have to be answered by anyone who wants to take issue with those facts. I don't have any instructions on it, because the position on the pleaded case is the seat remains Pretoria and has always been Pretoria. So, Justices, affidavit not in. If it's in, not something of which you can take judicial note when it contradicts the evidence. And then finally, not a simple thing even to state in an affidavit, because it requires a consideration of what is principle. And on the reasoning of Justice Rogers, two principles are not adequate for the purposes of our common law of jurisdiction.
I just want to come back to
Yes.
the issue you raised earlier about the authority of the minister to depose to this affidavit. He deposes as a respondent, the first respondent,
Yes.
who is a member of the executive.
Yes.
Are we to assume that in that position and with that authority, he is able to depose to this affidavit and to the facts in this affidavit is to his consent to jurisdiction?
Justice Aldana, the short answer
Why
is
do we
no.
need more? Why do we need more? That he has conferred with the president or or in cabinet? Do we need more than that?
Then he just says he consents and he believes there's jurisdiction.
No, with regards to his authority.
Yes, we do need to know that he speaks for national government. And the reason why is because of the other facts in this case. The other facts are the head of the executive does not consent and has indicated to this court that a submission of law was erroneously made. The court can't overlook, nor can Minister McPherson require the court to overlook that fact. The consequence of that is that to competently consent, and this is the second point, consent to jurisdiction is akin to waiver. Our law says it must be approached not synonymous with, but akin to waiver. It must be a submission with full knowledge of the circumstances, acquiescence in jurisdiction, and the consequence of which is that the conduct is incompatible with any other conclusion but one of submission. The facts that I've identified, Justice Saldana, in our submission already show that you don't have enough before you to be satisfied that national government, through the affidavit of Minister McPherson, has been apprised of these rights, apprised of the consequence of the submission, and through Minister McPherson are consenting to the jurisdiction of this court.
In the absence of anything to the contrary, are we not entitled to assume it by virtue of his office?
Certainly not. Not on the basis of the way these facts have unfolded. And the way the facts have unfolded, the court will be aware of. Minister McPherson, first of all, says he doesn't think he needs to provide any affidavit to this court. That's what began on Monday. He could just do it from the bar. With respect to my learned friend, when pressed by this court, the affidavit is produced. It is produced after argument about the position of the president in this case, after the president has indicated in his heads of argument about a month ago filed that he makes common cause with the legislatures on the jurisdiction point. Against that set of facts, our submission is you cannot assume Minister McPherson speaks with the authority of national government when he says, Justice Saldana, if we can just go back to that affidavit, it's the simplest paragraph to add to an affidavit. I have engaged my cabinet colleagues. I have raised the issue with the president. He doesn't do that. The language is quite important. It's always in the first person. It's his belief, it's his views, and it is I confirm that I consent. Even that sentence. For the consent to be effective, it must be national government, for whom I am the representative, consents to the jurisdiction of this court. Justice O'Donnell, we say much more was required in order for this court, with justification and confidence, to regard this as the voice of national government. But even if the court is not with me on that, the more important law point is consent can't cure the jurisdictional deficit of the DA's case, because there is no traditional ground of jurisdiction on which it can be laid. So on either basis, either the affidavit doesn't do enough on consent and lacks probative value and is legally irrelevant for the reasons I've given, or the court is against me on all of those submissions, says they can read in this that Minister McPherson engaged with Cabinet, got the okay to state as national government's position it is submitting to the jurisdiction. On the authority of Venetia Mineraria, which binds this court, that is not sufficient. There has to be a traditional ground. And for the reasons we've given Justice Saldana, we say there's no traditional ground established in this case. The last of those is the office. The office is not a recognized ground of jurisdiction on our reading on any basis. And Justices, I must just pick up on a point that my learned friend Ms. Pillay made on Monday. We relied in our heads of argument on the proposition that the residence of government functionaries, quasi-judicial statutory bodies, comes from the Patterson decision. And Justices, you'll recall Ms. Pillay said in relation to Patterson that that was an old case reliant on the 1961 Constitution, and I understood her argument to say should as a consequence be approached with some circumspection on this point. Justices, the answer to that is that Patterson has been repeatedly applied by our courts and applied in the case that the DA commends to this court for the other proposition in relation to the National Act basis. That's the Norkia case of this division, Acting Justice Cockrell. Justices, I'll just give you the paragraph reference there. In 26, Acting Justice Cockrell refers to Jassat, which is another judgment there of the Natal Provincial Division, referring to Patterson, which he then incorporates in reference in his paragraph 26. If I may give you the Jassat reference, it's 1999, 1 South African Law Reports, 156, a judgment of the Natal Provincial Division. And the reference to Patterson is at 160 H to I. So, Justices, the upshot is that you can't wish away Patterson. You can't wish away Patterson on the basis that it's old law. It's been repeatedly endorsed and referred to in cases as recent as Jassat and Norkie. It says, when you sue government, you must sue it for residence purposes at its place of principal administration. The facts before this court is that that is in Pretoria, and so the DA has failed to establish a jurisdictional basis for this court related to where the minister's principal location is. Justices, that concludes the argument on jurisdiction. I now propose to move to the merits, and I do two parts of argument there. I look at the mandates case, and then I'll look at the rules before I hand over to my learned friend, Ms. Zikalala, on Section 19. Justices, the mandates case, we say, suffers two fatal flaws. The first of those is that there's no constitutional hook for this attack. Justices, you will have seen our extensive argument on that in our heads of argument. The point simply is the following. When an act like the Expropriation Act is to be impugned as being constitutionally invalid, you must identify a provision of the Constitution which it violates. We've had days of argument invoking Section 25, the property right. That is a valid basis for invoking constitutional invalidity. The Act is unconstitutional because it illegitimately limits the right to property under Section 25. So what you're looking for when you impugn legislation as constitutionally invalid is the constitutional hook that's going to give the applicant the declaration of invalidity that it seeks. In this case, there is no constitutional hook. In argument, my learned friend Ms. Pillay referred to 3 sections of the Constitution. Justice Slingers, you may recall, I think it was on Monday, you'd asked about the constitutional hook, and I listened very carefully. Ms. Pillay had 3 candidates. She said there's section 44 of the Constitution, there's section 76 of the Constitution, and there's section 65. Justices, the first 2 of those can be swiftly dispensed with. Those are not pleaded grounds for jurisdiction, not pleaded grounds for the attack on the legislation anywhere in the founding papers. My dutiful juniors have done a search. They tell me you will search in vain for a reference to section 44 or a reference to section 76. Those sections, in any event, are not sections that are impacted by the mandate's challenge in this case. And they can't be, because what you're looking for in the constitutional hook is you're looking for the Constitution placing a positive obligation on the legislative process and then conduct that breaches it. The best example of that are the tagging cases. The tagging cases are cases concerning section 76. Justices, if you look at section 76 of the Constitution, it places a positive obligation on the National Assembly when it passes a bill. It must be referred to the National Council of Provinces to be dealt with in accordance with a particular procedure. We know how tagging cases work. Tagging cases are brought before the courts when the criticism is that a bill was incorrectly tagged. That's conduct by the National Assembly, which can be impugned because this is a manner and form provision of the Constitution. And if you tag a bill incorrectly and you nonetheless pass it, it can be impugned afterwards. That's no part of the DA's case. The DA doesn't say there was a tagging problem. Section 44, similarly, is not a constitutional hook. It's first of all not a pleaded constitutional hook. But Section 44 is a section about the legislative authority of the country is vested in Parliament and confers powers on the National Assembly and the NCOP. Those are not constitutional hooks for the mandate's challenge. There's nothing here that says something positive by way of obligation has to happen vis-a-vis mandates in order for legislation to be valid. So the only constitutional hook in the pleaded case is section 65. But the problem there is that section 65(2) is the candidate for the constitutional hook. And justices, we know that the DA concedes that there has been no breach of section 65(2). The only obligation that section 65(2) of the Constitution creates is an obligation for an act of Parliament to be enacted that is required to do certain things vis-a-vis uniform procedures for the conferral of authority. The DA's pleaded case is that it accepts there has been compliance with that provision. And once that is so, justices, there is just no constitutional hook. There's no way to bring about the invalidation of this Expropriation Act unless you can say the Expropriation Act is invalid to the extent that it breaches Section 76, not a candidate. Section 44, not a candidate. Section 65, not a candidate because common cause at 65 has been complied with. And the last attempt to raise 65(1) A and B is first of all not a pleaded basis, but again doesn't create obligations vis-a-vis the NCOP. All that it says is it stipulates who has votes and how many votes will carry the day in the NCOP. So the upshot of this first problem for the mandate's case is without a constitutional hook, there's no basis on which this court can invalidate the Expropriation Act. The second problem with this hook, if there was one, is that it entirely ignores the role of Section 116 of the Constitution. And Justice Saldana, with respect, there was a point in my learned friend's address where you yourself, with respect, raised the issue of, well, how does your argument grapple with 116? 116 of the Constitution, you would have seen in our heads of argument, is without doubt the most important section in the mandates debate. The reason why it's important is because it's the section of the Constitution that gives latitude, with awareness of the devolution of power within our state, to provincial legislatures to, quote, determine and control their internal arrangements, proceedings, and procedures, and to make rules and orders concerning its business. Justices, you would have seen the reliance we placed on the UDM decision of the Constitutional Court. UDM dealt with the equivalent provision, 57, for the National Assembly's latitude to create its own internal arrangements, proceedings, and procedures. That freedom, correctly so, is left to each of these legislative bodies. All that 65 does is 65 says each delegation has one vote, 5 will carry the day, and there must be legislation enacted to give a uniform way for the NCOP to receive those mandates. In other words, you couldn't have different types of mandates emanating, because otherwise you can't operate in the NCOP. But the most that the Constitution does is says that's the arrangement. For the rest, we leave the provincial legislatures to design their internal rules. And justices, you would have seen the wisdom of that in the affidavits and the facts. Those provincial legislatures know how they function. They know that they sometimes are called on to give mandates before they have a formal sitting. So they have detailed rules about how they deal with that. Well, then a committee will meet and the committee will say, Speaker, give the mandate, but then the Speaker will place it before the House at its next sitting for ratification. That is fairly and squarely and correctly left to the provincial legislatures because they know how they function. The DA's case doesn't grapple with that at all. With respect to my learned friend, until Justice Saldana, you raised that question with her, the DA's case has never grappled with Section 116. It is the second answer to the absence of constitutional hook. First, no hook. Secondly, if we look at the Constitution fully and expansively, we see that actually this power is left to the legislatures to decide for themselves. And on the authority of UDM, for good reason. Courts shouldn't second guess them. The National Assembly shouldn't second guess, nor should the NCOP second guess what the provincial legislatures have
So
done.
how does the Western Cape deal with final mandates and voting mandates?
Justice Saldana, I don't know the answer to that. I think
Somewhere there's an attachment with the rules of the Western Cape.
I wasn't aware of that because it wasn't a challenged provincial
No,
legislature.
it wasn't, but it would be interesting to know
It would,
how they
certainly.
deal with the exigencies.
As I stand here, I do not know the answer. We can certainly look for it in the lunch break and address your lordship, address you, Justice Saldana, on that. But the detailed rules that we do see and which form annexes to the notice of motion are all those legislatures where there was a challenge, not including the Western Cape. So, Justices, that's the first reason why the mandates challenge cannot be upheld. The second reason is based on the Mandates Act itself. And for that purpose, Justices, we have a bundle of statutory authority. You may well have a copy of the Mandating Act yourselves. We did make additional copies, so if it would be of use to the court, we'll hand those up. It will also be useful for my learned friend, Ms. Zikalada, because she'll make reference to one or two other statutes when she stands up. But the only point I'd like to take the court to is some features of the Mandating Act. Justices, part of the challenge for the DA in mounting the mandates challenge is that they actually have a complaint about what the Mandating Act, they say, properly interpreted requires. They say, properly interpreted, the Mandating Act requires mandates to be given in plenary session by the provincial legislatures. That's their case. Now, I emphasize that only to say the Mandating Act and the Expropriation Act are both acts of parliament of equivalent status. And it's a point that my learned friend Mr. Maineche made yesterday in dealing with other challenges to the Expropriation Act and the Superior Courts Act. You can't challenge as unconstitutional one act by saying it's not the same or consistent with another act of parliament, right? So this is another way of making the lack of constitutional hook point. If we are at the part of the mandates case that is looking at the interpretation of the Mandating Act at all, rest assured we are not in constitutional invalidity territory, because all you're doing as a court is identifying what the proper meaning of a Mandating Act is, which might give rise to certain consequences in provincial legislatures, but what you don't do is elevate that to a constitutional infirmity. But let's even take the Mandating Act on its terms. In our submission, the Mandating Act, properly interpreted, does not require or stipulate that mandates can only be given by the provincial legislatures sitting in plenary session. And the reason we say that that is so obvious is because the Act uses the word plenary. If the Act uses the word plenary, and as the DA you want to bring home your argument that you can only confer lawfully a provincial mandate in plenary session, well then we must look for that word plenary used in the context of provincial legislatures in the Mandating Act. Justices, that's the one place plenary is not used. If we go to the definitions section of the Mandating Act, you will see that there is a definition of NCOP. NCOP means the National Council of Provinces referred to in section 42(1)(b) of the Constitution. The next definition, Justices, in our bundle, I apologize, it's at internal page 37. You'll find the copy of the Mandating Act. And in case lines, I see we're down at tab 25 at page 1453 after multiple dead trees, unfortunately. But page 37, there's a definition. NCOP means the NCOP referred to in section 42. Immediately afterwards, NCOP plenary means an ordinary sitting of the NCOP. Then you move further down the definitions. Provincial legislature. Okay, so we've got a definition of the national body for the provinces, NCOP. Now we have a definition of the provincial legislature in that same legislation. It tells us that's a provincial legislature contemplated in section 104. And then the gap. No definition of provincial legislature plenary. If Parliament wanted to use this Act to stipulate, notwithstanding section 116 of the Constitution's demarcation of freedom to the legislatures for how they govern their internal arrangements, if notwithstanding that constitutional stipulation, the legislature wanted to prescribe that only provincial legislatures sitting in plenary can confer mandates, the single thing you needed to have in this Act was a definition of provincial legislature plenary, and then you would need that to be utilized in the operative sections of the Act, like NCOP plenary is used. But you would have seen from our heads of argument, the operative sections 5, 6, and 7 that talk about negotiating final mandates and 5, 6, and 8 and voting mandates never refer to a provincial legislature plenary. That, we say, is the end of this case on interpretation of the Mandating Act. Without a reference in the Mandating Act to provincial legislature plenary, there is no hook for the mandate challenge for the DA, And we have a more fundamental argument than that. Correctly so, there is no such stipulation in the Mandating Act, because then it would be liable to constitutional challenge because it fails to leave what 116 of the Constitution expressly leaves to the provincial legislatures. All that 65.2 does is says, Parliament, you can prescribe a uniform procedure so that what comes to the NCOP is the same thing, because they can't be dealing with different types of mandates from different provincial legislatures. That's the sum total of the national oversight. But once that's done, 116 says, provincial legislatures, you go about your business. You arrange your internal rules, and we are not stipulating to you that you must confer mandates only in plenary session. It's not in the Mandating Act, and we say could not be, because a constitutionally consistent reading of the Mandate Act means that that must be left to each legislature for their own determination. Justices, those are the arguments in relation to the mandates challenge.
Well, I raise with you
Of course.
the provinces, and you're going to come to the
Yes.
rules just now, that makes provision for ratification. And the concern raised is that you can ratify a mandate after the NCOP in plenary has already taken a vote and made a decision. And that defeats what is referred to as the voice of the provincial legislature as opposed to the people. Are you going to deal with it later? Or
I am indeed, Justice Saldana. I'm happy to give an overview of the point now, though, and I'm indebted to your question. The moment the DA, in its papers and its heads of argument, starts to talk about the voice of the people, the adequate representativity for the people in the legislatures around the country, we must all know they are in the territory of public participation and its adequacy. Because all of those points are points about how do we ensure in the legislative process that the will of the people is being adequately respected and represented. So, Justice Saldana, my crisp answer to your question is, if that was the DA's complaint, and fairly, it could have been the DA's complaint. If they say ratification subverts the will of the people and their voice in the legislative process, that is a claim they could have brought as a failure of public participation. But they avowedly told this court they weren't going to do that and hadn't done that. And I'm back right where I began. It's a point about election. It's a point about how the DA decided to run this case. There is a mandates case potentially available along these lines. It just isn't the one before you. If their real challenge is ratification is inconsistent because it happens after the fact, you will not hear me say that's not an arguable case, but then they must bring it. They must bring it in the exclusive jurisdiction of the Constitutional Court, which they recognize can only deal with public participation cases, and they must run a case there about why ratification subverts the voice of the people, and that must be their case. It's just not the one before this court for adjudication.
are you moving away from mandates?
I am, subject to
you-
further questions.
Well, the argument that they raise also is that even with your rules on delegation, you've not complied with your own
Yes.
rules.
Yes.
Are you going to deal with that, or
That I certainly am in the rules section.
are you in the
I'm-
rules section going to
yes,
deal that they've not complied with their own rules?
absolutely. Justice Saldana, so if I may move to that, because the rules is my next topic. In order to do the rules, there is the factual case on mandates that it's important to just bear in mind because of something that appeared in the founding affidavit and also was then taken up by my learned friend Ms. Pillay in argument. There's this theme claim in the mandates case that this was all on the whim of the speaker. You'll remember that those were the words of my learned friend, Ms. Pillay.
She corrected it and said...
Indeed, behest.
Yes.
Indeed. I took particular note of that. But it's important that reference was made to that because the DA's case, when it launched, was all about speakers acting unilaterally. Unilaterally in breach of their own rules. Unilaterally without proper authority and delegation. But what each of the provincial legislatures did in their answering affidavits was to take the court chapter and verse through their processes. Laboriously so. Every meeting. What was happening on the 12th of March? What was happening on the 13th of March? What happened on the 19th? And they needed to do that because they were confronted with facts about what had gone on in those provincial legislatures, despite the representation of the applicant, the Democratic Alliance, in those provincial legislatures that were simply wrong. So much so that the legislatures were troubled. They said, but this is misleading the court if you say these speakers were acting on a whim. They weren't. Justice Saldana, you referenced some of those facts. Those speakers act on the facts, not on a whim or a frolic or unilaterally. They act after, in each case, a committee first meets. It first meets and it says to the speaker, this is the mandate that must be given, and our rules permit you to give the mandate because the House cannot convene again between the 12th and the 13th, or our members are out on the ground speaking to the people and we can only come back. Those on the facts, there are not breaches of the rules. On the DA's pleaded case in the founding affidavit, there is an appearance of that breach. But that is because the case as pleaded was a case about speakers on frolics of their own. I made a note of the facts in relation. It's the provincial legislatures of Limpopo, Mpumalanga, and the Northern Cape, in respect of which the DA, in reply, does retreat from the factual position and does offer that apology, at least in 2 instances. So we even know that case is not a case that can be carried through even to the replying affidavit. And Justice Saldana, the remaining legislatures, Eastern Cape and Gauteng, have gone on oath and explained how, notwithstanding the rules that the DA says were operative, the DA has overlooked other rules that governed the proceedings. There's a case, I think it's the Eastern Cape or Gauteng, where it's just the wrong rule. They rely on the rule.
Eastern Cape.
It was the Eastern Cape, wasn't it? Ordinary rules affecting the provinces versus others. The DA goes for the rule that wasn't the operative rule. The legislature dutifully informs the court we were operating in the other rule. The sum total of the facts on the provincial legislatures is that there is not a factual case for a provincial legislature acting in conflict with its rules. Either there was the required ratification by the House or deemed acceptance by the House. There's a particular set of facts, Justices, that I did want to take the court to, just in the light of some of the engagement between Justice Saldana, you and my learned friend, Ms. Pillay, because you referenced in particular the facts about ratification. And if I stand back for a moment, ratification, if we're in a voice of the people case, does jar to some extent. It happens after the event, right? But what is reassuring about the facts that each of the provincial legislatures put up is that those facts explain precisely how those ratifications occurred. And Justices, they occurred with full knowledge and with unanimous assent on the part of the Eastern Cape. I'm just trying to find my reference to that.
Full knowledge of the applicant.
Indeed, full knowledge of the applicant. The reference is 007-207, paragraph 54. Justices, we begin there at 007207. It's the full circle to the plenary nature of what the DA says is the requirement for provincial legislature mandates. I've addressed the court already on why that's not a legal requirement. But even if the court was troubled by the need for overall assent from the House insofar as the mandate is concerned, you have it in 007207. There, in the Eastern Cape's affidavit, we have at 53, well, before that, we have how if we could go back to 205, just starting at 52. What happens is after the NCOP process, the House, we're at paragraph 51, convenes its first sitting since the final mandate was signed and issued by the Speaker. At 52, we're told the transcribed record of the House sitting on the 2nd of May records the final mandate was put to the House by the Deputy Speaker for ratification as part of the 6th order, and that the mandate was adopted unanimously by the House. But the Speaker didn't stop there. We have the transcript over the page at 206, and then at 207, where I'd wanted to rush ahead and take the court to, what the affidavit says at paragraph 54 is, it's clear from the transcribed record of the proceedings of the House on the 2nd of May that, 1, the final mandate was put before the House by the Deputy Speaker. 2, the Deputy Speaker asked at least 3 times whether any members of the House had any objection to the ratification of the final mandate. 3, the Deputy Speaker went so far as to ask members of the House specifically to unmute and agree. And then 4th, no member of the House indicated any objection to the final mandate being ratified, such that the House unanimously ratified the final mandate. These are the facts that the DA has to grapple with if it wants to ever bring a public participation challenge pursuant to the role of ratification in the individual provincial legislature's processes. It's going to be met with these sorts of facts. Facts that say that by virtue of ratification, you get assent by all of those attending the House on that day, unanimously so. So, Justices, those are the facts against which the lawfulness of the giving of the final mandates must be assessed.
There was the concern about the Speaker had not conferred with the leaders of the political parties in the House.
Yes. That fairly was accepted when that had occurred by the provincial legislatures. The provincial legislatures say, though, their rules accommodate exigency of circumstances that make that impossible to achieve because they have these provisions for later ratification or deemed assent. So it is so. There were occasions where that engagement did not take place, but the legislatures still say we're not foul of our rules because we know how these things work. We know how we are beholden to a legislative calendar from the national parliament that we do not control. We know that we can't always take every step in the process, but we have these safeguards along the way, and our rules accommodate that. So, Justices, again, insofar as a constitutional challenge to the mandates is concerned, the difficulty for the DA's case is that they will constantly come up against 116 of the Constitution. 116 of the Constitution says in the devolution of power, provincial legislatures know best. Provincial legislatures must design these rules because they know what the workings of their particular legislatures look like, how big they are, how often they meet. The challenge is you can't impugn for constitutional inconsistency these regimes when there is a latitude given in the Constitution to the legislatures designing these rules in ways that work for them. So the challenge for the DA is at 2 levels. On the facts, we say there has not been non-compliance with the rules. At the higher level, the rules are not inconsistent with the Constitution because of the provisions of 116 and because of what the Constitutional Court said in UDM is the important latitude left to legislatures to govern their own procedures. Justices, I know that we are a few minutes before lunch and I'm moving to my next topic, so I wonder if it would be an appropriate time to take the adjournment.
Before you do,
Yes.
Ms. Lacey, they are not challenging the constitutionality of the rules if it's not necessary for the legal proceedings. But to the extent that it is, they have not abandoned
Yes.
constitutional challenge to the provision.
Yes. Justice Slingers, can I address you on that in two parts? When I first read the DA's heads of argument, I thought they had abandoned the challenge. And so I was somewhat reassured with respect when you put the question to my learned friend. I then went back and was reaffirmed by Ms. Pilley's answer. I understand them to say they don't need the declaration of invalidity because of some sections of the Constitution that render inoperable certain rules when they conflict with national legislation. So I'd like to just address that point first and then come to the linkage point, which is the second. Justice Slingers, you will have seen in our heads of argument, we say their reliance on the FedSAS case for the rules governing conflicts in the Constitution to operate here simply doesn't apply. And the reason it doesn't apply is for two reasons. The first is that those rules apply when there is a conflict between national and provincial legislation on a functional area of concurrent legislative competence in Schedule 4 of the Constitution. That's when those rules apply at all to resolve conflicts. Our first argument is these rules are neither provincial legislation, properly understood, nor even if they could be understood to be some species of that, are they legislation in a functional area in Schedule 4. And Justices, we set that out in detail in our heads of argument, and I heard no counter to that from Ms. Pilley. Ms. Pilley does not identify a functional area of concurrent national and provincial legislative competence in Schedule 4 of the Constitution, which she says these rules fit into. Now, if that is so, this case can't be resolved on the conflict rules in the Constitution because they only apply to conflicts between national and provincial legislation falling within a Schedule 4 functional area. So they can't take the benefit of the inoperability provisions of the Constitution because they can't get themselves into those conflict provisions. But even if those conflict provisions could, on some basis that I have not yet heard from the applicant, apply, the next problem for the DA's argument is there is no conflict. And that is because of the argument I've already addressed to the court. There's no conflict because the rules permit the grant or conferral of a mandate other than in plenary session by the legislature. And I've taken the court already through the Mandating Act. The Mandating Act similarly does not require mandates to be given only in plenary sitting of the legislature. So if that is so, there's no conflict for any work of constitutional provisions to resolve. Remember, the postulate is you've got national legislation, the Mandating Act, on their version requiring the giving of mandates only in plenary session, and then you've got a series of rules that don't do that. That's their case. We meet it at 2 points. We say no conflict because the Mandating Act doesn't require the conferral of mandates only in plenary session. But at the second level, they can't use the conflicts rules because they just are not applicable. This is not national and provincial legislation in a functional area of Schedule 4 of the Constitution. What that all means, Justice Slingers, is they don't get the benefit of inoperability, right? So then they're back in their case for invalidity. And as I understood Ms. Pilley, she said they have not abandoned that case. To the extent that they need that case to get their relief on the Expropriation Act, they persist with it. Our answer to that is you only get that relief if you have shown an inconsistency between the rules and the Mandating Act. And for the reasons I've already given, there is no such inconsistency because the Mandating Act in terms does not require mandates to be given in plenary session. The legislature used that word for NCOP proceedings. It never used it for provincial legislature proceedings. And we say correctly so because it can't regulate that field. It must leave that field pursuant to Section 116 of the Constitution to the provincial legislatures. If you step back from it, it all makes sense. The Constitution says, I need a uniform procedure to receive mandates in the NCOP. Parliament, go and give us that act. Parliament does. When it uses plenary, it speaks to the NCOP plenary. It doesn't stipulate to the provincial legislatures how they must confer mandates because they know these provincial legislatures have to grapple with their own internal workings. And it knows 116 of the Constitution says, don't go there. You must leave that fairly and squarely to the legislatures who know best. If you come back with that vantage point, the mandates case with respect evaporates. Because the constitutional scheme is such that you leave this to the legislatures. The legislatures have done so in terms of their rules. Those rules have not been breached because they deal with these difficult factual scenarios that have played out in the papers. And so when I address the court right at the end after my learned friend is finished, I'll go through each of the prayers in the notice of motion and summarize for the court why we say none of that, if you ever get over the jurisdictional difficulties in this case, should be granted to the DA.
The practical aspect is that in one of the legislatures, the ratification took place 2nd of May.
It did.
And that was literally months after even the National Assembly had adopted the Act.
Indeed, Justice Saldana, I had a sense you might be most troubled by that one, which is why I took the court to that one moments ago. That's the one where the Speaker asks 3 times. Maybe the Speaker was concerned similarly. We've met 3 months later. It was the first next sitting of the House. Everyone, please unmute. Tell me, is there an issue with the unanimous assent? No one puts up their hands. The legislatures dutifully performed in terms of their rules. And for the reasons I've already given, those rules don't require the plenary giving of the mandate to begin with.
We also don't know what happened on the in March when it went to the plenary
Yes.
of the NCOP. Is there a record of proceedings in respect of that vote?
Yes,
Is there-
certainly. Oh, Justice Saldana, that's such an important point, if I may, with respect. It's something I do want to pick up on after the break,
Okay.
because there was objection raised in the NCOP, and I'd like to take the court to how the NCOP rules deal with that, and why the NCOP must be able to rely as prima facie evidence, unless contradicted, on those mandates. Our system of provincial legislative passage of laws could not function unless you have rules like this that set a default. Prima facie proof, unless other. And I'm going to take you to where the NCOP chairperson explains there was no contradictory evidence placed before the NCOP. If there was a moment for the Democratic Alliance to take issue with the passage of this bill, it was then. They noted an objection, but there was no supporting evidence placed before the NCOP. The NCOP can't then do anything. It's got mandates. It's got mandates coming up to it from the provincial legislatures. If there was a case to be brought, again, it's all about election. Then in that moment, if the DA had been poised to run this case about ratification not being adequate, about speakers being on frolics of their own, they know the rules in the NCOP. That's where they needed to bring evidence to counteract the prima facie status of those mandates. But that doesn't happen. I'll take the court to those facts after the lunch adjournment, if I may.
Very well. Should we adjourn for lunch? Mr. Boston, good to have you back today. All
I
good?
apologize for my disappearance yesterday.
No, we're a bit concerned, but you're all good?
I'm all good, thank
Very well, thanks. It's lunchtime. It's the best time of the day. Thank you, Ms. Hoffmeyer.
Thank you, Justice Saldana, Justices. Probably the good news is that I don't have terribly much more to say at this stage, given the exigencies of time. I did, however, want to pick up on the point Justice Saldana I left off on before lunch, which was to just deal with some of the facts about what happened in the NCOP. That's on the 13th of March, 19th of March, and thereafter. But in order to properly frame those facts...
Is it on the record?
It is indeed. And maybe I'll just give you the reference to begin with. You'll find it in 006-29. So that's page 29 of tab 6. That's a section of the NCOP chair's affidavit that begins with the heading, "The process followed in the NCOP." And I'm going to pick it up from about paragraph 66, which is over the page. But I do want to frame that for the court before I go there, once the court has the papers to hand.
Should we just hear it? Should we just listen to it? Let's just listen. Yeah.
Thank
Do you
you.
want to roll? Thank you.
Thank you, Justice Saldana. The context in which I would like to place these facts is actually the context of the Constitutional Court's judgment in Mohale. And the reason why I propose to take the court there is Mohale is an important case. The applicants also think it is an important case, so we make common cause on that. Mohale was a case challenging public participation in the passage of the Traditional Leadership Act. And it's an interesting case because there was a mandates issue in that case. My learned friend Ms. Pillay flagged that for the court on Monday because it's dealt with in paragraph 17 of that act. So there's a mandates issue, but there is an overarching case about public participation and its adequacy. And so it goes on the exclusive jurisdiction to the Constitutional Court directly there. The point that it's important for me to highlight for this court, though, is what Justice Theron, who wrote the unanimous judgment of the court, said around paragraphs 58 and 60 of that judgment. At 58 and 60, she's dealing with the assessment of the public participation process, and she flags that one of the complaints by the applicant there was that 3 provinces' final mandates referred to the incorrect bill and were therefore not valid votes cast. So that's part of the factual matrix of the case before the Constitutional Court in relation to Mohale. But after the judgment sets out the multiple failings in the public participation process, which in that case critically included failures at the public hearings. People weren't given on the record an adequate opportunity to be heard and were closed out unceremoniously. It's the point at paragraph 60 of that judgment that I commend to the court. The Constitutional Court says there, it would be an impossible standard for Parliament to comply with if a single flaw in a single hearing rendered the entire public participation process unreasonable. And what that meant for the case is that when you run a case about the passage of legislation and your underlying complaint is a failure of public participation, what the Constitutional Court is saying is you can't prize one failing in that process, for example, an invalid mandate or a hearing that doesn't give adequate representation, because the legal standard against which public participation is assessed is a reasonableness standard. You have to look at the whole process cumulatively, and then the court has to look at all the facts and say, was there a deficiency of public participation overall? The reason I go there is in relation, Justice Saldana, to one of your questions before the lunch break What if there is one legislature who didn't comply with its own rules? What if there is, as a consequence, one mandate that doesn't follow its internal procedures? You've heard me on the facts. We say that that's not the case, but imagine there is one or even two. What the Constitutional Court is saying is when you seek to invalidate legislation at the end of a parliamentary process, then you have to cumulatively look at how good that public participation was, and you have to make an assessment. Now, if we step back from it, probably mindful of that limitation to a complaint about mandates, the DA has been express in this case. It's not bringing a public participation case. That's why it's not within the exclusive jurisdiction of the Constitutional Court. But we say that decision or that choice it made doesn't free them of the import of this judgment. What our law doesn't recognize is a single flaw in a legislative process for which there isn't a constitutional hook as a basis for invalidating national legislation. I emphasize for which there isn't a constitutional hook because the cases where there is a hook are the tagging cases. The tagging cases are cases where there's one event. It's the failure to tag a bill correctly. And our courts have said, and the Constitutional Court has endorsed this, those cases can give the basis for a constitutional challenge. Why? Because there's an express obligation on Parliament to tag in a particular way. So when you present your notice of motion, you seek the invalidation of, for example, the Expropriation Act to the extent that it failed to comply with Section 76. It's easy to run that case, and it's a case that's available to applicants because there's a specific duty on Parliament. The problem in this case is, you've heard me already, no constitutional hook vis-a-vis mandates, and not even in the Constitution a requirement that mandates be given in plenary session. So we say not even facts to support it. And Justice Saldana, that's the backdrop against which this court, were there to have been a case about the deficiencies in the NCOP, would have to evaluate all of these facts. And my first point, and I must be clear on it, there is no case that seeks to invalidate the vote in the NCOP. That became clear on Monday, where with respect, Justice Saldana, you asked that question of my learned friend, and she had no response to suggest that is their case, right? Their case is certain things happened in 5 provincial legislatures beyond the territorial jurisdiction of this court, which in their own terms weren't in compliance with their rules, or their rules are constitutionally invalid. We say for reasons they can't get over the line. But if we look at what happened in the NCOP, we just see how difficult this type of complaint is to get over the line. In the NCOP, we first of all have the sitting of the Select Committee. That occurs from, the details of that begin at paragraph 65 of the NCOP's affidavit at page 00629. The Select Committee explains the receipt of the mandates. It goes on at paragraph 67 to say the following. In terms of Rule 103.14 of the rules of the NCOP, the authority conferred on delegates must be determined in accordance with the process of the relevant provincial legislature. So there's actually a synergy between what the provincial legislatures prescribe and what the rules of the NCOP recognize. That process is for them to determine. And then 103.17 becomes important. In terms of that rule, the following is stated. The production of a final mandate in the prescribed form constitutes prima facie proof of authority unless proven otherwise. And then the NCOP chairperson on affidavit says no formal proof or evidence was presented by those who had objected to the sufficiency of the final mandates to rebut that prima facie validity of the mandates. And the affidavit goes on to explain, well, absent such a challenge, we know what the rules say. The rules say the final mandates are good enough. They stand as prima facie proof unless the contrary is proved. Nothing is presented by way of proof to the contrary. So the processes of Parliament must continue, and they do. And the next thing that happens over the page at 32, paragraph 72, is we have the final NCOP convening on the 19th of March. At that meeting, there is a signaling from the applicant's representatives that there's going to be an intention to challenge the legality of the bill. That's given on the 19th of March. They don't do anything, though. They don't run to court there for an urgent interdict. If they've got a legality case, maybe they need to be in court to stop this process if they think they have enough to stop it. Because we know over the page that it is then transmitted to the National Assembly, and the National Assembly's concurrence is achieved on the 27th of March. Justices, the reason why those facts are important is because of what the Constitutional Court said in Mohale. Quite frankly, the DA would have been hard-pressed to run to court after that event. They produced no contrary proof to undermine the prima facie receipt of those mandates as valid mandates in the process. They also would probably have struggled to convince a court to interdict the process when the word from the Constitutional Court is you don't do parliamentary processes by prizing one event in the passage of legislation and saying this whole thing must come crumbling down because of one event in the passage. Because that is our law, what it allows is Parliament to run its processes, deal with its rules, get to the end of the process, and if on promulgation of the Act, you've got enough deficiency in the process to run a public participation case, the case that really gets to representative democracy's problem, which is voice of the people, then you bring that case in the Constitutional Court on a cumulative assessment of the facts. You've heard me on that. That's not the case that was brought. These are facts that I highlight both in answer to Justice Saldana's questions, but also to highlight this is a tricky case, a pure mandates case to bring on one mandate. The single mandate in the Mohale case, well, the three that referred to the wrong bill, themselves were not enough to invalidate the process. The court was clear, we have to look at it cumulatively. And when they reasoned, the court there for what undid the Act in the end, it was principally the failures in those public hearings to adequately reflect and receive the views of the public. Justices, if that is so, then there is no way in which the complaints about these mandates rise to the level to produce a constitutional challenge resulting in invalidity for the DA. What we next need to consider is the final submissions I have on the rules, if I may be permitted to go there. I did, in fact, in answer to Justice Slinger's question earlier, give most of my argument there. There are really 2 points to be made. The first is that the rules are not unconstitutional. They're just simply not unconstitutional because the Constitution does not demand that provincial mandates can only lawfully be given in plenary session. It says that nowhere. On the contrary, it says in section 116, for good reason of separation of powers and devolution of power in our constitutional scheme, we leave it to the provincial legislatures who are best placed to manage their internal arrangements to work out what processes they will go through to ensure the giving of authority for provincial mandates. If that is so, there's just no way to use the mandates in this case to impugn this legislation. And we say that the DA, as a consequence, has failed to bring home its mandates case. Yes.
The fact that there is a provision that gives the Speaker a delegated power to sign off on the mandates and for it to subsequently come back to the provincial legislature for ratification, is that not imply that it's the provincial legislature that would and ought to have given the mandate, but for exigencies?
Justice Saldana, I do think that is so. And it was actually a feature of a point with respect you made earlier in the week, I think. The whole point about ratification as a vehicle in the law
It's ex post facto.
is ex post facto, and by its nature imbues that which was arguably less than what was required with the lawful authority required. So unless you say ratification cannot be a feature of provincial rules, it will cure any problem that the exigencies of a situation created for the need for the mandate to be before the NCOP.
But would you accept that in the absence of an exigency, that it goes to the plenary of the provincial legislature?
Justice Saldana, I wouldn't even go that far because I don't want to be prescriptive to the provincial legislatures. Each of these provincial legislatures know how they function. They know how big they are, how often they meet. What they must do is they must design a process for their rules to give 3 types of mandates to the NCOP. And the appropriateness of each legislature's rules will be a function of their particular circumstance. So I am not to be heard to give a single answer for all legislatures. I think we must be sensitive to their each individual position. Their rules must speak to their each individual position and how they function. And what is appropriate in one circumstance may be different in another. We know in this case, some of the legislatures do confer a power on the Speaker. Others don't. They, through the cut and thrust of their processes, have worked out what works best for them. Importantly, the Mandating Act does not say you have to do it in the same way within your legislatures. You've heard me already. We would say that's constitutionally inadequate or indeed in conflict with 116, because you must leave that freedom and that ability to be responsive to each provincial legislature's particular circumstance to the legislatures. Justices, those are our submissions in relation to jurisdiction, the mandates challenge, and the challenge on the rules. My learned friend Ms. Zikalala will now address you with your leave on the Section 19 challenge, and if I may be permitted just a few moments after that to conclude on some aspects. We're indebted to the court. If you would just give us a moment to move ourselves into position, we will do that as swiftly as possible. You go. Yes. I'm going to put it here.
May it please the court, justices, as my learned leader has already indicated, I will be addressing you on the DA's challenge to Section 19.2 and 19.3 of the Expropriation Act. Justices, I've listened carefully to the submissions that were made by our colleague for the president in relation to those submissions, and we make common cause with much of the legal submissions that have already been made. And so I will not be repeating those submissions, and in particular the legal propositions that were made by Mr. Manecha for the president. However, for purposes of our submissions, there are 3 topics that I would like to be able to outline, which ultimately underscore why the provincial legislatures and the parliament support the president's remedy in respect of the reading in. The 3 topics I propose to address briefly is how the error arose. Now, Mr. Manecha has already addressed that, but I just want to touch on 1 or 2 facts, because the issue of how the error arose speaks very much to the fact that the error is one that is identifiable, that it's curable, and that it's narrow. Secondly, I would like to be able to undertake a fairly close reading of the Act, to be able to situate why ultimately the remedy that is proposed is the appropriate remedy, given the circumstances. And thirdly, Justice Saldana, I will address you briefly in relation to the question you had posed to my learned friend for the president in respect of the excision of the words notice of expropriation in the Act. I propose to deal with that particular submission last because I think in the flow of things, it might become clear as we go through the Act why that might not be appropriate. Justices, as a point of departure, it is correct that Section 172(1)(a) obliges a court to declare any law or conduct inconsistent with it invalid. That submission was made and was made with much force on Monday by our learned friends for the DA. But there is one important textual qualifier that we must emphasize. The Constitution says that such a declaration of invalidity must be done only to the extent of its inconsistency, and no more. The Constitution's express default is to impose the narrowest effective cure, and this is out of respect to the separation of powers and Parliament's law-making function. Now, we listened very carefully to the submissions that were made by Ms. Pillay for the DA in relation to the error that is in Section 19.2 and 19.3. We think it is important to underscore that no submissions were made as to why the error which we have in our heads of argument outlined as a trigger, the issue about when the clock begins to run, a trigger problem. There were no submissions made as to why the trigger problem should result in the Act in its entirety being struck down. It was for the DA to justify why the most drastic remedy available, striking down an entire Act for a trigger problem confined to a single phrase in 2 subsections of the Act, would be just and equitable. Given the express constitutional injunction to declare law or conduct invalid to the extent of its inconsistency. And I had wanted to just place that up front. I want to deal with the first topic which I had outlined, which is how the error arose. For purposes of your references, Justices, I don't need you to turn here, but if I can give this to you. This is outlined in the National Assembly's answering affidavit, and if I can give you the reference, it's at para 32, case lines 006-87 to para 61, case line 006-94. Justices, as Mr. Manetha has already outlined, the error is best understood by following how the bill proceeded through Parliament. The original version of the Act permitted expropriations to take place before compensation had been agreed, in line with the then Hafiji, as Mr. Manetha had outlined. So expropriations in the original bill were compensation disputes in the original bill were a post-expropriation issue. So the determination of compensation disputes would be determined after the expropriation. In clause 21 of that bill, which has subsequently become section 19 of the Act, that bill permitted a party to approach a court within 180 days of the date of the notice of expropriation. On that original scheme, that trigger event was coherent because the dispute process followed the notice of expropriation. During the clause-by-clause deliberations that were taking place in the Portfolio Committee, a decision was made to move the determination of compensation disputes from being a post-expropriation issue to being a pre-expropriation issue. Then, amendments were then made to Section 7 and 8, and throughout the Act to make that coherent in the Act. save for the fact that there was one cross-reference that was left from the original bill. And that is the cross-reference that we see in section 19. What we see as the error in section 19(2) and 3 is frankly the error to have made a consequential amendment to the Act once the decision had been made and the amendments had been made to section 7 and 8 of the Expropriation Act. The National Assembly's answering affidavit states as much, and if I can just give you this reference, Ms. Pillay had already given you this reference, but if I can also give it to you, this is at paras 60 to 61, case lines 006-94. The National Assembly explains in its affidavit that the inconsistency that one sees in section 19(2) and 19(3) arises from the fact that Parliament erroneously did not make the necessary consequential amendment to then clause 21 during the legislative process of the bill. The upshot of this is this. The error is not a flaw in the design of the Act. Parliament deliberately and coherently changed the design of the Act and did so in section 7 and 8. The trigger problem that we see is one that is as a result of a failure to have made that change in the cross-reference which was left behind from the original bill. That is the whole of the defect. It is one that is narrow and one that is identifiable. Now, I'd like to be able to proceed to the next part of my submissions to be able to show you why we say when you look at the Act closely, you can see why this error, the failure to have made the consequential amendment, is one that is both identifiable and curable just based on looking at the Expropriation Act. Justices, Ms. Hofmeyer handed up the legislature's statutory bundle of authorities. Can I ask if you have that statutory bundle of authorities at hand? Okay, thank you. In its case for why a reading in remedy would not be appropriate in this case, the DA makes 3 points. It essentially argues that there's a range of possible cures that exist, that choosing between any one of these possible cures is a decision that is to be made by Parliament, and that the reading in must be done with sufficient precision. I will show you now, in terms of the Act, why we say that the reading in remedy meets each one of those 3 requirements.
But before you start, perhaps just Parliament made the error. Should Parliament not fix it?
Justice Aldana, it depends fundamentally as to what the error is. The court has a range of remedies that it must apply. In terms of section 172(1)(b), it must also determine what is just and equitable in that basis. So it is not always that error must necessarily go back to Parliament. This is why you have a range of remedies that exist. You have severance, you have reading in, and or to refer it back to Parliament. So it's not necessarily that it is for Parliament necessarily for the reading in remedy to go or the issue to go back to Parliament. It depends what is just and equitable in the circumstance.
And then just following up from that, the nature of the error relates to a policy shift in the process of the bill. A policy shift took place from the initial draft to to the draft of Parliament with regards to when the legal challenge should take place.
Yes.
It's a fundamental shift.
The error is not in relation to the policy shift. The error is as a result of the failure to have made the cross-reference. So the policy shift, the decision in respect of the policy shift, is coherently set out in the Act. That is in Section 7, that is in Section 8. We know that that disputes relating to compensation are determined prior to expropriations taking place. No one has challenged that policy decision. The question really is one of a cross-reference back to Section 19. If I might take you through the Act, and I will show you, yes, that is addressed. So the first place I'd like to be able to start is, the Act starts at page 10 of the bundle, but I'd like to be able to start at page 11.
Of which is the statutory bundle.
Of the statutory bundle. At page 11, there is the definition of what is a disputing party. The term disputing party is defined in Section 1 of the Act, and it states that a disputing party means an owner, mortgagee, holder of a right. I'll skip a few words, go to the last end of the sentence, who rejects the expropriating authority's offer of compensation. So, a disputing party, Justice Manu Lockwood.
Yes, I've got the statutory bundle. Page 11.
It is the Act. So you've got a copy?
This is the Act, yeah.
Yeah.
I'll use my copy of that.
Yeah. You got it?
Which I can't find.
We have so many copies of the Act.
I want my copy. So, provision, you said?
So I'm starting at Section 1.
Thank you.
And we're looking at the definition of a disputing party.
Yes.
A disputing party is defined as an owner, mortgagee, holder of a right, and as I said, I skip a few words, but I go right to the end. And it says, who rejects the expropriating authority's offer of compensation. In terms of the Act, the defining moment is the rejection of the offer of compensation. It is at that moment in the Act that the Act converts a person who was merely an owner, a mortgagee, or a right holder into what it terms a disputing party. The term disputing party is one of significance for Section 19 because that term is used operatively only in Section 19. I want to, and this is important, I'd like to give you one reference. So I maintain that term is used operatively mainly in Section 19. There is one other reference that says disputing parties in Section 16.3. I would like for the court to be able to just make the note. When you read it, you will see that contextually it is not the same as defined in the Act, but I'd like for the court to be able to have that reference. Now, the reason why, but nonetheless, even if you take that reference in Section 16.3 into account, it doesn't change the analysis going forward. The term disputing parties is one that is used operatively in Section 19. So if one goes to Section 19, and in the statutory bundle, that is at page 18. In order to fall within the ambit of 19.2 and 19.3, you have to be either an expropriating authority or a disputing party, which again means that you must have rejected the offer of compensation. So the question then that follows is, when in the Act does it say that you have rejected the offer for compensation? That takes you to Section 7. Section 7 deals with the notice of intention to expropriate. In terms of the notice of intention to expropriate, the offer of compensation is first made in terms of Section 7(2)(k) of that provision. So in the notice of intention to expropriate, that's when the offer is made. So the rejection of the offer must be after that point in time. And that follows if one looks at Section 7(4) of the Act. At Section 7(4), my learned friend for the President has already taken you there, so I won't belabor it, but at Section 7(4), a person responding to the notice of intention to expropriate is within 30 days. They're given a number of options, but at 3. So 7(4)(a)(3). Disputes in terms of Section 19 the amount of compensation offered. So, the Section 7(4)(a)(3) notice, written statement, is the statutory mechanism by which the rejection of the offer of compensation occurs. It is notable, Justices, that in Section 7(4)(a)(3), it expressly refers to Section 19, because it says disputing, comma, in terms of Section 19, the amount of compensation offered. What then is the upshot of this analysis? First, we know from the definitions that one has to be a disputing party, and that you have, from that definition, you have to have rejected the offer of compensation to come within the terms of Section 19(2) and 3. We also know from Section 7(4)(a)(3) expressly, that refers back to Section 19, that that's when the rejection of the offer for compensation occurs. Now, I want to be able to deal with the range of possible alternatives that have been put forward, but there is one thing that I need to be able to address quickly, which is when my learned friend for the DA, Ms. Pillay, gave her submissions on Monday. She indicated that, well, the National Assembly says it was the legislative intent that it was one thing, and then the President says it was the legislative intent that it was another thing, and that they point to different legislative intent. That is not the case. And I would like Justices to refer, for you to please take the reference down in the National Assembly's affidavit, para 66. Case lines 006-96. In that paragraph, the National Assembly indicates that it was the legislative intent to refer back to the section 74A3 notice. And that would have been consistent with the deliberations. And we see now, from a reading of the Act, that is also how the express provisions of the Act read. Justices, can I ask, this is important, can I ask that you turn to paragraph 100 of the founding affidavit? The DA's founding affidavit. Page 002-34.
Say that reference again.
002-34, the DA's answering affidavit. The DA's case has always been that there's a range of possible options that could be pursued, and this is why any reading in remedy would be inappropriate. My learned friend for the president has already indicated that the range of possible options would have to be range of possible suitable options. And there would also have to be a range of possible options that are consistent with what we have gone through in terms of the Act, how the Act is structured. So initially in the founding papers, the range of possible options that were given by the DA were 3. And those are the ones in paragraph 100. Those range of possible options seemed to have mushroomed to about 9 by the time we got to argument, but we're not certain how it said that they mushroomed to about 9 and whether those are suitable. So I'm addressing now the pleaded case in relation to the range of possible options. The first of the range of possible options, already addressed by my learned friend for the president, is that the trigger point, the legislature's intended trigger point, was supposed to, and here, that Parliament could replace, and I'm reading from paragraph 100.1, that Parliament could replace notice of expropriation notice with intention notice. So essentially, the notice of intention to expropriate. We have now done the exercise of looking at the Act. We know from looking at the express words in the Act that the rejection of offer for compensation can't be when the notice of intention to expropriate arises. So on the case law and on the submissions made by the president, that would not be a suitable alternative, simply because that is not faithful to the text, the existing text of the Act. And this is important for the reasons already given by my learned friend for the president. But in relation to the notice of intention to expropriate, at that stage, no dispute has arisen. So a person can't then be said to be a disputing party. I want to consider then what is said to be the third at paragraph 100.3. And the argument there is to say, well, the other range of possible options is that Parliament could craft a provision in which the 180-day period begins once parties finally fail at mediating or reaching consensus on compensation. So to use mediation by itself as the trigger date, the trigger point. But that is also not a suitable alternative for the reason that in terms of the express provision, section 19.1, mediation is optional. You can choose whether you want to mediate or you can choose not to mediate. So if you peg the running of the provision from the date in which mediation begins to run, you leave a category of parties out, those who do not want to mediate.
But it says parties finally fail at mediating or reaching consensus on the compensation. So implicit in that is either they don't reach consensus or they fail at mediation.
Correct. Correct.
So it's not only triggering leaving it to mediate
Yes.
or mediation.
Yes. Justice Slingers, I somehow left out that last bit. If then one reads 102 and 103, that is then the remedy that is proposed by the president, and that is the one proposed by the legislature. Because it is the remedy that one takes into account mediation, but not necessarily all reaching consensus, but takes into account the moment, the express moment in section 7483, that is in the Act. That is the remedy alternative that has been proposed by the President and supported by the legislature.
So if I understand you correctly, President's proposal, which is supported by your clients, is a combination of the proposal made by the DA of the second and third proposal combined, read together.
So, yes, but it emanates primarily from a reading of the Act. The first proposal, the one at 102, that proposal is the one that I have showed you expressly exists in the Act. That is the rejection of the offer for compensation that exists at 7483.
Which triggers section 19.
Which triggers section 19.
So we
That
shouldn't
is
look
also-
at it- Sorry, we shouldn't look at it individually, but rather read it conjunctively.
You read it conjunctively. That, and it's important, the only quibble or the only thing I want to clarify is that it's not the DA's remedy alternative. We are starting from looking at what is faithful to the text of the Act.
Sorry,
And
I'm
the-
just
yes.
interested in it.
That is the remedy alternative, the one that is faithful to the text of the Act. The 17483, which in relation to paragraph 100, that's paragraph 100.2. Now the second trigger point is, and if I can take you back to the Act. Looking at section 19. 19.1. Section 19.1 is the provision that deals with mediation. And it says, if the expropriating authority and a disputing party do not agree on the amount, time, and manner of payment of compensation, they may attempt to settle the dispute by mediation. But this is the important part, which must be initiated and finalized without undue delay by either party. And the point that I wish to emphasize, that we wish to emphasize there, is that the Parliament expressly contemplated that mediation ought to be able to initiate and be finalized. And the time yardstick that it put for the initiation and finalization is undue delay. That's not an undecided issue in the Act. It is there. They provided for initiation and finalization of the mediation without undue delay. Now, the remedy alternative that has been put forward caters for those two decisions. The first is when the rejection of the offer for compensation occurs, when the written statement is delivered. The second is the termination of the mediation, the termination of the mediation without settling the compensation dispute.
Could I just come back to what Mr. Manechi argued, that the sense of what was being allowed by Parliament is to give parties the opportunity of being able to find themselves. They must have the opportunity to be able to enter into negotiations, take advice, alternatively go to mediation. On the date of rejection, there's been no negotiations at that stage.
For purposes of mediation.
On that day,
Yes.
on the 7/4,
7-4.
on that date, there's been no negotiations. And you can't expect the clock to start running from that date. Because the parties must be given the opportunity of negotiating. So assuming you get somebody who rejects, but in the meantime is not able to obtain advice with regards to negotiating, but the clock is ticking, unbeknown. So should the 180 run from the date of rejection?
Justice Aldana, I will refer back to the definition. At the point at which the party rejects the offer in terms of the definition, they become a disputing party. Because that's when you reject the offer for compensation in Section 1, that's when you become a disputing party.
And so the time runs against you from that time?
From that, because you have been given the offer for compensation in the notice of intention to expropriate.
Yes,
You've been given 30 days to consider it.
yes,
And then you are given a decision point is then made.
right.
When you exercise that decision point and offer the note and give the written statement in terms of Section 7(4)(a)(3), in terms of the current wording of the Act, that's when you become a disputing party. That disputing party then has an election.
Yes,
That election is either if they want to continue to negotiate, they can enter through Section 19 by Section 19(1), the mediation provision.
yeah.
If,
Let's just pause for a second.
okay,
So the disputing, or the person says, I reject, and then becomes a disputing party, but doesn't begin a process of negotiating within the next week or so. But in the meantime, the 180 days is running against that person. And that's cutting into that person's time on the 180 days in which they are able to find themselves either by negotiation or when the mediation breaks down. You're cutting into their time.
Justice Aldana, I understand the proposition that you're putting to me, which is that after a party has disputed that, should they be permitted to then continue negotiations?
Well, remember, up until that stage, they've not negotiated at all. They've been given 30 days to go through a probably a fairly voluminous document with research, possibly even further particulars. And so now they've at last come to a date and they say, I'm sending a letter of rejection. But negotiations hasn't started from that date.
Yes. The option given to that party is then to enter mediation in terms of Section 19.1.
Not only mediation, to enter into negotiations also.
Justice Saldana, I cannot locate where that
Well,
would be in terms of the
why-
Act as it
Let's look at
currently stands.
19, because 19 says, may attempt to settle the dispute. See, so are you saying that the Act doesn't make provision for negotiations?
It does.
Where?
It does because you can accept the offer for compensation,
Yes.
or you can reach the offer of compensation by consensus.
Where's that?
You can reach the offer for by consensus in Section 19.2.
But in terms of section 7, I understand the party may request
Further particulars.
work.
Yes.
And it's at that point really that the election is made.
Well, if the party requests further particulars, the election to negotiate or to mediate.
And it's mediation that provides the platform for settlement or whatever it is, section 19.1. Isn't that how it's set out? They may attempt to settle the dispute by mediation.
Yes.
That's where they, as I understand it, that's the scheme of the act.
That's the scheme of the Act. So
So one is mediation, two refers to consensus. Consensus may be in the absence of a mediated process.
yes.
And so there needs to be, the parties simply just negotiate with one another.
Yes.
But if you're simply relying on mediation and you're excluding a time for negotiation, that's the concern. And so the parties are given an option. You can negotiate, and sometimes even when the negotiations break down, then you might decide to go to mediation.
Yes.
But you've got to recognize the period that they'd be negotiating with one another.
Yes.
And if you're saying that there's no period allowed for because of 19.1, then 19.2 becomes meaningless when it talks about consensus.
Yes. Justice Saldana, I understand the point. I will just endeavor to come back to it.
Certainly.
because what is important to bear in mind is that there is this process given in the Act for parties through the mediation. And so I do think that it is meaningful that the mediation does exist for parties as a means of being able to reach that. So, but I understand promptly that the question is whether the negotiation itself should have a time period allocated to it.
Well, it doesn't have to be in the Act, but it must make provision for it. But the concern is that when your time starts running from the date of the rejection letter, that's the concern, because you then don't take into account the period of negotiation. Whereas you make provision in the alternative that the 180 days will run from the end of the mediation.
Yeah.
So why date of rejection?
Date of rejection is because that is the date on which a party becomes a disputing party in terms of Section 19.
Yes,
Between-
but even
yes.
as a disputing party, you then enter into negotiations.
Yes. Yes. No, I take the point. I guess the submission would also be that in that process of trying to reach consensus, that the Act does allow, as currently formulated, for the period to begin to run.
To begin to run.
For the period to begin to run. Yes.
The
Because
180
otherwise,
days.
yes.
So the gong goes off at date of rejection.
The gong goes off at a date of rejection unless a party enters into Section 19.1 mediation. Enters into Section 19.1 mediation or negotiation. If I might just...
No, it can't be all negotiation. So if you're saying all mediation, it means you are negotiating from the date of rejection and you come to day 160 of negotiations, but your time is run out already. For you to get ready for the time to start your legal proceedings.
The Act does not preclude negotiation before the alternative of mediation. But the point is that the process by which the negotiation may be for both negotiation and mediation. The Act specifically says that that process must take place without undue delay. The only point of the 180 days is to make both parties act swiftly in order to be able to ensure that there's the finalization of disputes. Because the state cannot expropriate until compensation is determined. Because of the change of the policy position from compensation disputes being a post-expropriation issue to a pre-compensation issue.
So there's a way in which to read, you say sub 1 as in where it refers to mediation, they may attempt to settle the dispute by mediation. There's a way in which to read that as including the consensus referred to in sub 2.
Yes.
But one doesn't say that.
Yes.
But if you try to marry the two.
Yes. Because ultimately what one is trying to do is to be able to give parties the option or give parties the ability to be able to resolve the matter without having to have recourse to court. So it is consistent with that, with both a textual and a contextual interpretation of one. In that process, one can try to reach the process either by consensus or by a recourse to mediation in sub 1 to allow for that period of negotiation.
Sub 1 doesn't refer to a consensus.
Consensus. Yeah. Yeah.
So sub 1.
So would the parties then have basically 180 days within which to finalize mediation or reach consensus? Because that 180 days starts running from the notice, the written statement in 743. So you've got 30 days once you get the notice to expropriate, you're given 30 days. Then if you refuse or disagree on the compensation, you give the written statement, and you've got 180 days either to reach consensus or to mediate. And if you don't reach agreement, either by mediation or negotiation within that 180-day period, you then need to be in court before that period runs out. Is that how I am to understand the provision?
Justice Slingers,
The proposal.
yes. Justice Slingers, I understand what you're putting before me. I just quickly need to be able to take an instruction on that one. Yes. Justice Slingers, yes, I'm being. If I might ask,
You want to pause
because
this?
I think it is important to be able to narrow in on this particular point. If I might ask, if I might be able to confer, because this is a position that's being taken by both the president and the legislatures, and for us to be able to come back to you on that particular point.
Certainly.
Yeah, I understand.
So we don't. Is there another topic you want to move on to?
The last topic I want to be able to deal with is in relation to the excision of the words notice of expropriation that you have proposed to my leader for the president.
So why don't we leave that for last?
Yes, we
Maybe after
leave
we
that for
resolve
last.
this, because we were able to get some clarity from positions, then the other one becomes easier, I think.
Yes. Yeah. Yes. If I might ask that we then stand down now and then we will address both after.
Certainly.
Yes.
This, do you want
Cool.
to?
10 minutes.
Do you want us? Well, we can.
Or we can do it tomorrow morning. I can finish and we can come back.
I think you want to not be rushed with 10 minutes. Just take your time on this, without pressure. 20 to 4. Ms. Hofmeyer, are you able to wrap up your section?
That's what I was going to propose, Justice Saldana. If you don't mind, we'll complete all of our submissions but for this aspect. Then we can use the adjournment time to
Certainly.
resolve it, and we can address it first thing tomorrow morning,
Very well.
if that suits the court.
Good, thank you.
Thank you, I'd appreciate that.
Ms. Clara, thank you. Sorry for putting you under this pressure. But it's late afternoon on Thursday. Thank you for your patience with the court.
Okay. Justices, there are just a few submissions in conclusion to make, both to just take the court back to the notice of motion, if I may. I seem to have lost my notice. Here it is. And what I thought I would do just to summarize the position of the legislatures was to take the court through each of the prayers and crisply summarize our position in relation to them and then give you our position on costs. But before we get to the prayers, of course, we have the ever-present issue of jurisdiction. If the court were to conclude that it does not have jurisdiction in this case, we say the appropriate order is to strike the matter from the roll. That is actually in the interests of the applicant. The reason why courts do that when they lack jurisdiction is because the issues do not become res judicata between the parties, the consequence of which is that if the DA were then so minded to launch in another court, they would be open to do so. So one doesn't always realize that that's actually to the advantage of the applicant. It's like urgency being struck from the roll doesn't preclude the applicant from coming again. It just means that this case won't be determined here, and jurisdiction has a similar consequence. So we say if you're with us on jurisdiction, you will strike from the roll with costs. Justices, if you're not with us on jurisdiction and you're in the merits, then I'd like to take you through each prayer. The first prayer of the notice of motion requires a declaration that the 5 impugned mandates were invalid and inconsistent with the Constitution. I'm paraphrasing there. The reason, in summary, that we say that prayer should not be granted to the DA is because there is no constitutional provision that requires mandates to be given only in plenary session. The only way the DA gets that order from this court is if they've managed to convince you that there's a provision in the Constitution that requires that, and you've heard our argument for why they have failed to do so. If we move to prayer 2, prayer 2 actually reveals the absence of the constitutional hook point that we've taken before the court today. The reason I say that is the single thing that's missing from prayer 2 are the words "to the extent that." Remember, section 1721A says a court may declare legislation invalid and inconsistent with the Constitution to the extent of its inconsistency with the Constitution. So you always, as an applicant for constitutional relief impugning an act of parliament, have to have those words there. It is noteworthy we say that Prayer 2 does not have those words. Prayer 2 says the Expropriation Act is declared to be inconsistent with the Constitution of the Republic of South Africa and invalid. We say lurking in the absence of the words "to the extent that" is the fundamental failing in their mandate's case.
But doesn't it follow from the fact that they're asking for the validity of the entire act?
But the constitutional rigor, and this is a point my learned friend Ms. Zikalala made, for separation of powers reasons, you have to be specific about what part of the Constitution it engages for its invalidity. So you would usually read, to the extent that, I gave the example in the tagging cases, to the extent that it did not comply with Section 76, to the extent that it breaches Section 25, if it's a property right. You always have to put the constitutional hook in the "to the extent that." The point here is, yes, they know they want the whole thing declared invalid, but the constitutional discipline is to say, to the extent that it violates the Constitution. Well, tell us what the extent is, applicant. We don't have it here. We say...
Didn't Ms. Pillay explain that this is targeting both strands of her case?
Indeed. So I must be clear on that.
Yes, it's not just about Section 19, the Section 19 issue, it's also, it includes the mandate.
Yes, so Justice Mamklu Lockwood, can I be clear? The point about the absence of the constitutional hook is a point about the mandates case. You've heard me on that. They can't give you a section of the Constitution that says mandates have to be given in plenary session. And I say that failing in their case is evident because they don't have the "to the extent that" language there for the mandates case. What they could have in 2, but they bring into 4 later, is it could be "to the extent that" Section 19.2 and 19.3, if you go over the page, or on your same page, Prayer 4, those sections require parties to approach a court within 180 days of the notice of expropriation. There they've been expressed. That's their Section 19 case. My learned friend Ms. Pillay was clear to say they don't only run that alternative case, they also run a case that says because of the problem in 19.2 and 19.3, the whole act can fall. But then Prayer 2 needed to say, to the extent that the 19.2 and 19.3's reference to that language renders the act irrational or renders the act inoperable or unworkable. That's what you find in the explanation in paragraph 61 of their founding affidavit. What I'm making plain here is that any order under 2, if this court were minded to give it, would have to have greater precision and would have to explain the basis for invalidity, whether mandates or Section 19, and would have to say far more than is currently there to be an order compliant with Section 172(1)(a) of the Constitution. It's just helpful if we do for a moment look at that language. I can find somebody will give me, we have multiple constitutions flying around. Let's just get the language. When deciding a constitutional matter within its power, a court must declare any law or conduct that is inconsistent with the Constitution invalid to the extent of its inconsistency. My learned friend Mr. Kalala made the point better than I could. That is a separation of powers reason. You can't just invalidate, you have to hook the invalidation to something in the Constitution. I readily accept it can be irrationality reasons, vagueness reasons. These have all been reasons why legislation has been impugned. But you need more words there. And all that I'm saying for the purposes of the mandates case is there's never been a constitutional hook for Prayer 2 insofar as mandates are the basis on which the act would be invalidated, so they can't get Prayer 2. If they could get Prayer 2 at all on the Section 19 case, you'd have to have been satisfied that this single curable error, which is a product of a legislative process that failed to cross-reference properly, is enough to invalidate this entire act. And that we say they haven't come close to achieving. Prayer 3 is a to the extent that the rules they want struck out. You've heard us on 2 grounds there for why that prayer shouldn't be granted. The principal one is that those rules are in no way inconsistent with the Constitution. The Constitution leaves the latitude to provincial legislatures under Section 116 to make of their rules what works for them. And then, Justices, finally, on Prayer 4, you've heard from my learned friend, Ms. Zikalala, if we get over jurisdiction, if you're in the merits, then you've heard from Parliament today what the appropriate reading in remedy is. It's a remedy that cures this defect. And Justice Saldana, just in relation to a question that you asked earlier about if it's Parliament's error, why doesn't it go back to Parliament? There's one feature of this case that explains why this shouldn't go back to Parliament. Usually Parliament isn't a cited party in these cases. The usual cited party is only the national minister representing government, because that's what our law says we need to have as the voice from the state about the passage of legislation. It just so happens, because the DA had a mandates case as well, that you have the NCOP and the Speaker here, and so you actually have an indication from Parliament that if you follow its process diligently, you'll see as a court, as it has recognized, there was an error in an updating of a cross-reference. And that's why, if any remedy were to be given, we say it's the reading in remedy consistently proposed by both the presidency and the legislatures, but with the question that we are holding over to tomorrow to be resolved in due course. Justices, finally, just on costs, the NCOP and the Speaker took the position in their papers that if they were to succeed, that BioWatch would apply and they would not seek costs. That remains the position in relation to those 2 national houses of Parliament. But insofar as the provincial legislatures are concerned, you would have read in those affidavits, the provincial legislatures took time and care to explain to this court how inaccurate the DA's founding papers were. They claimed that speakers were on frolics of their own, acting unilaterally. Those facts are just not borne out. On 3 occasions, the DA in reply had to retreat and apologize for those errors. We say that is not becoming of an applicant of the stature of the DA, and punitive costs were sought by those legislatures. And they stand by that request for punitive costs. Those were facts known, they say, or at least readily ascertainable by the deponents to those affidavits, and they say they were averments as a consequence made recklessly. Justices, those are our positions in relation to the relief sought and the costs sought by the legislature respondents. We are at a few minutes to 4. So unless there are further questions for me, those are our submissions. We will, of course, revert in the morning on the question about can you negotiate and mediate in the 180 days.
Don't tempt us to ask you any further.
No. Thank you, Justices.
But might I just get clarity with
Yes,
regard to
of
the
course.
one issue? Is the affidavit filed by the Minister?
Yes.
Mr. Katz gets the opportunity of responding
Of course.
to your application for it to be struck out. And at some stage we'll have to deal with that.
Indeed, certainly, Justice Saldana.
Might I also then just ask from the President, that affidavit also impacts on the President. Are you going to be arguing the same as Ms. Hoffmeyer?
Well, we won't say anything more than just associating with their submissions. We won't be saying, making any separate submissions on the affidavit. And we will associate with the submissions here.
Okay. But there's factual issues dealt with in that affidavit.
As far as we're concerned, there isn't, the minister is not saying anything about the president or the cabinet. He's just speaking for himself as described in that affidavit, his position in that affidavit. And we do not have any more submissions to make.
You heard what I had raised was that he assumes his authority for the affidavit from his executive position.
Yes, we understand that. I mean, that's the same authority, I think, he described in his explanatory affidavit.
Yes.
And so if the court accepts that that description was good for the explanatory affidavit, it will probably be good for this affidavit, but we have nothing further to say. And
You're not saying he doesn't have the authority to say what he did in the affidavit, because he had the authority, I must assume, to say what he did in the explanatory affidavit.
as I submit, if it was good for the explanatory, it's probably good for this affidavit. But Ms. Hoffner makes a different point about the probative value of the affidavit in respect of the jurisdiction, submission to jurisdiction. The president hasn't submitted to jurisdiction. The other ministers haven't submitted to jurisdiction, but the issue whether the affidavit properly submits or equates to a proper submission to jurisdiction in law is a matter that we're not addressing. It's an issue Ms. Hoffmeyer and Mr. Katz, I suppose, must address. Otherwise, we abide the decision of the court.
Very well. Yeah. It's supposed to be. But is the president not supposed to be?
Yeah.
He makes the choice.
Yeah. No.
My license.
Justice Salgana, Justice, the reason the affidavit was introduced was in response to the software's submissions on jurisdiction and the attempt to cure that problem.
Yes.
We, as I've always indicated, the president hasn't taken an issue on jurisdiction, highlighted the concession he made, and we have characterized that as a concession of law, which is not binding on the court. To the extent that there's an issue about the admissibility of the minister's affidavit, its probative value on the question of jurisdiction, and whether, even if it's accepted, it cures the problem with jurisdiction, is a matter that's disputed between Parliament and Mr. Katz. Parliament has addressed that issue fully. Perhaps it is only just that Mr. Katz, given that we have 5 minutes left, says his 5 cents worth on the issue, and tomorrow we can carry on with what we need to carry on. Otherwise, I can't help the issue by speaking about the minister on behalf of the president. I just don't know. I have no instructions on what the president's reaction is to the affidavit. His cabinet minister doing what he's doing. All I know is what the president has put out on. If that assists, I think Mr. Katz should speak for himself.
Do you want to hear now? She doesn't need it. Listen to his text. You want? Yeah. These are just some of the thoughts that we want to put to you.
Yes.
We definitely don't want to put Mr. Katz on the spot now to have to respond. He must have the time to do so. But we've raised with you very specifically the issue of the authority and of the minister with regard to the affidavit in which he consents to the jurisdiction of this court. We don't know whether it's with or without the consent of his executive, which is part, or the president. And you must consider how you want to deal with
Justice
it.
Saldanha, I'm not even certain that a minister responsible for a portfolio allocated to him under Section 91 of the Constitution requires the president's consent to come to court and explain his position in relation to legislation undertaken. The Constitution places the obligation on that minister to come to court to assist the court in the manner he sees fit. This minister has chosen to do so by filing an explanatory affidavit which doesn't address all the issues that need to be addressed by a minister when a legislation is challenged. In the course, an issue has arisen about jurisdiction, and that minister has chosen to cure a problem facing a party, a litigant against the state, by consenting to jurisdiction for reasons that are not apparent to anybody to see. Whether that is a proper assistance to the court or is not, it's a matter for the court to determine. And if the court has questions about how the minister has conducted himself, it's a matter his legal representative should deal with. The president doesn't instruct cabinet ministers on what to say in court proceedings in defense of legislation or not in defense of legislation. That's for the minister to decide. He's got his cabinet members are collectively and individually responsible for the discharge of their constitutional functions. And this minister has an individual responsibility to assist the court, and he must answer for himself on the choices made on how to assist the court. There is no authority required to depose to an affidavit. As long as you can say, the facts are within my personal knowledge, you can sign an affidavit. So he has done so. The consequence of that legally is the debate between Ms. Hoffman and Mr. Katz. We like to keep our, I think the idiom is the powder dry, or whatever it is. We're not involved in that fact.
We're staying out of this.
Staying out of it, we're dealing with the merits of the service. There's a conflict.
Hold on, just hold on. Are you finished, Mr. Maneki?
Yes, still if the court is happy with hasn't got further questions.
Well, we've
response.
raised with you what the issue is about authority, and we're not taking it further except for having raised it with you, and you also make choices.
Yes, we make the choice that the minister is, the president has by proclamation assigned functions to this minister, which involve administering this act. This act is under challenge. The Constitutional Court has made it abundantly clear repeatedly that a minister in that position must come to court and assist the court on whether the provision is unconstitutional, what is the explanation, is there justification, and put up the evidence for the court to make an evaluation. It's left the president to be involved in that function, and other ministers from other portfolios to be involved in that function. To the extent in that in the choice that is made of how he's going to assist the court, issues have arisen. He's got counsel in court to address them, and that is the extent to which I think I can be of assistance, Justice Saldanha.
Yes. It was also raised on Monday that if there were any questions that the court wanted to raise with regard to any issue in respect of the challenges, that would take place before you argued.
Yes,
we did not raise any issues.
Yes.
With Mr. Katz, we did not seek to hear what the minister's view is, because it would obviously be improper given that he's not filed an affidavit with regard to those issues, which would be the basis on which he seeks to argue the law.
Yes,
Important policy decisions have been taken in this legislation. And he hasn't set out what his position is on those policy decisions
Yes.
on the legislation, which is under attack. As we hear, the entire legislation must be set aside.
Yes.
But that's where we left it on Monday, and I think we must leave it there today. Except just to hear what Mr. Katz has to say.
As the court
Thank you,
pleases.
Mr. Madam.
Donna, I will literally be known for 5 minutes on the one issue, and that is the admissibility of the affidavit. I will not go into any other issue. Unless, would you like me to hear me now? Or just to save time, get me off the, I don't have to stand up afterwards. I don't want to stand up tomorrow, I don't want to stand up next year when this case is done. Just get rid of it. Because really, it's simple. I'm going to make a very simple solution. There are 5 points.
Clock stops ticking. 5 minutes.
Yeah, 5 minutes, Mr. Katz.
I'll try. 1, this is an application to admit an affidavit under 6.5e. The court has a discretion. The key aspects applying that discretion are: why is it late? Why is it now? And 2 is there prejudice? In the minister's affidavit, he says there is no prejudice to the other party, to the amici, or to the court. That is not taken issue with by anybody. Why is it late? Well, he explains in detail why he didn't believe it was necessary. And for that proposition, I want to read one sentence from a judgment of this court of 2014, and that's Justice Sikiso. It's in the applicant's supplementary bundle, page 7879, case line 241297. And this is what Justice Sikiso says. Further,
What's the name of the case, please?
Johnson versus Minister of Home Affairs. And I was for Mr. Johnson, and Mr. Borgstrom was for the second applicant, the law is for the campaign advance. And this is what Justice Yukiso said. Furthermore, and I'm not saying this proposition that Justice Yukiso is correct. I'm making the proposition as to why the minister was late and why the minister was fathered when he fathered. And it was reasonable and appropriate for the minister to do what he did. And this is what Justice Yukiso says. Further, the national executive, and then the important words, as all of us have come to know, comma, has 2 principal places of business, one in Tshwane and one in Cape Town. And I gave the advice to the minister to say, that's the law. I might have been wrong, but there's a judgment of this court which says this. I know that Ms. Hoffman says, well, Justice Yukiso was out of touch with the true cases which were Patterson. She says that. And she can have that fight with Ms. Pillay. I'm not getting involved in that fight. As to the question of jurisdiction. So the minister says, well, I, as a minister, take the view that Justice Yukiso articulated 12 years ago. I consent to jurisdiction, it wasn't necessary, but to the extent that there is this now fight, by, and this is the last point that I'm going to make, not by the president, not by another minister, by another arm of government, and if ever you've had a separation of powers issue, Ms. Hoffman has walked straight into it, where the speaker said the minister can't do what he's doing. That's not appropriate. In a case where she said 20 minutes ago, normally in these cases, the speaker isn't cited. And the reason for that is because the speaker's got no interest in the Section 19 challenge. She has an interest in the mandates challenge. Last point. The minister has no issue, one way or the other, in respect of jurisdiction or any interest, not any interest, in any comment on the mandate challenge. It's way out of his remit. It's only a question of Section 19. The speaker has no role in that challenge, as far as the minister is concerned. And that is a separation of powers concern that I asked the court to take into account in respect of the speaker's travelling in a lane that is not hers. Only on Section 19.
Mr. Katz,
Finish 5 of this.
so why was it necessary for you on Monday morning, before the proceedings started, to make a declaration on behalf of the Minister on jurisdiction? Why? if your minister believed it was not an issue, why Monday morning, the declaration?
No, sorry, the question raised, let me put it this way. The minister takes the view
Yes.
that none of this was necessary. If you want to criticize the minister, or me personally, not the minister, for making the declaration on Monday, ex abundante cautela, out of abundance of caution, criticize him. But the point is, this is a separation of powers issue, and I'll ask the court to take it into account. Only for the section 19 point, nothing else. It's not for the speaker to be, and she said it, she said normally these cases the speaker doesn't get cited. Why? Why she cited it as a man that's shown, which is not within my. So the point I make is,
Mr. Katz, on Monday we didn't hear you qualified this declaration.
excuse me?
On Monday morning you did not qualify the declaration.
No, I did. Oh, absolutely.
No, you said the minister wants to place on record
Yes.
that he consents to this court's jurisdiction. And the question, in the light of his affidavit, why was it necessary for him to do that?
Because, well, well, if the court takes the view that it's not necessary because the court has jurisdiction anyway.
We don't take that view, no, don't put an end to what the court may decide. I'm saying that on Monday, the minister in his affidavit says, I assumed that this court had jurisdiction.
Yes.
Why on Monday morning
No.
do we have this declaration?
I'm sorry, with respect, what I remember saying, I'll check the record, and the rest of the court correct me if I'm wrong. What I said was the only, when I placed myself on record, I said the only reason I'm here is to answer questions and I informed the court that the minister takes the view the court's got jurisdiction, no more, no less. And then Ms.
Sorry,
Hoffman
hold on. He said the minister consents
Yes.
to the jurisdiction of this court.
to the extent that it was necessary. And then Ms. Hoffman spoke and I qualified what I said. And I said, by the way, that consent only applied to section 19 of the manual. I did do that. I did do it. I was very clear.
Yes, but it was the consent.
I did do that. I was very clear, and I've been thinking about. I argued Johnson all those years ago. It's me. Johnson. So it's not as if it's somewhere out the air, and it's been going. I mean, I was Darwin.
Judge Slingers wasn't Johnson.
Excuse me.
Judge Slingers says it
She
wasn't
remembers,
Johnson.
and you can ask Justice Slingers what happened when it got to the Constitution. They didn't deal with jurisdiction, but the appeal didn't succeed. Justice Slingers will report.
Your 5 minutes is over, my 5 minutes is over. And everybody else's 5 minutes is
We've
over.
heard about so many things.
Don't tempt him, please. Thank you, Mr. Katz. You've obliged to have the affidavit.
Indeed.
Straks, you'll get a chance tomorrow to,
Thank you.
and not today,
Indeed. Not.
if there's anything else to be said.
Thank you, Justices.
I suspect that, is anybody else who wants to say anything about this beleaguered affidavit?
No one else.
Ms. Pillay, you shake your head.
Nothing from us.
Thank you, Ms. Pillay.
Justices, we are a little concerned where this whole jurisdiction points leaves the other three applicants because jurisdiction was not raised. We were invited to this court after we issued our application in the correct court, and it was with the consent of all the respondents at that time in that application. All of them have consented in our application, and I think Mr. Father's application as well to the jurisdiction of this court. So if you waste the whole day on a point in limine that should have been raised on Monday, I'm not sure.
Huh? Tomorrow morning. Oh. Good. Is there anybody else? Yes, the Emperor. Yes, sir.
As it is the court, Honorable Justices, my only concern is that judging by the number of people that are still going to talk, and looking at the time that most of the people take, 3 hours, I doubt very much if tomorrow will all be accommodated. And for me, it's a big concern. Well, first of all, I live in Johannesburg and I've been here for almost 5 years. I don't know whether it is proper to say if we don't finish tomorrow, let's run to Saturday, so that we don't have to push into Monday and Tuesday next week. I don't know how, so.
Thank you. The Emperor raises an important issue with regards to, realistically, are we going to finish tomorrow? Amongst ourselves, we had thought that we should ask you perhaps just to bring your diaries tomorrow if we do not finish tomorrow. Realistically, we still have some work to do, and in fairness, we've got to give everybody a fair chance of being able to present. The respondents are still midstream, and then each of the amica have the opportunity of addressing the court, and then of course the applicants have the opportunity of replying. And so realistically, the Emperor is correct, we're not going to finish tomorrow. But I hardly suspect that we are going to be able to sit on Saturday, given people's other commitments. Everybody, large part of the team comes from Johannesburg, Pretoria, and they've got flight arrangements and all of that. Besides that, the court, I can't speak on behalf of my sisters. Pardon? My sister's right, she says, even if we sat on Saturday, we might not finish. And so realistically, we'll have to talk very hard about exactly how many days we need to finish. Unfortunately, Amber, you've raised it, and thank you for doing so. But I doubt we're going to finish tomorrow, and that we're going to have to start looking at further days. Next week is also not practical for us because each of us are in trials that are ongoing. We've been plucked out of those trials to come and spend a full week here. So it's not possible for us to simply reconvene, and I suspect each of the council here also have other commitments that they need to honor to their clients. So tomorrow morning, will you bring your diaries? And so at the end of tomorrow afternoon, we could just look at what is realistic in terms. We might not be able to settle the date because amongst yourselves, you would have to go through a round-robin process. But let's just agree in principle as to how many more days we would need. And realistically, when can those days be found in our diaries? If you do that, is that? Ms. Hoffman, are you?
No, not at all. Thank you, Justices.
Because never ask me to time to talk. When I get a time, and then I'll respond.
No,
in
certainly.
20 minutes. So thank you everybody for the day. That's why we've had today, Mr. Manechi, you finished off. Thank you. And then we got into Ms. Hofmeyer and Ms. Ikalara. Thank you. And we'll hear a bit more from you tomorrow morning. Thank you. And that's it. So thank you everybody for your cooperation and patience with the court today.